Hey. All persons having anything to do before the Honorable, the Justices of the Appeals Court, now sitting at Boston within and for the Commonwealth. Draw near, give your attendance, and you shall be heard. Now state the Commonwealth of Massachusetts, court is open, please be seated.
Good morning, everyone, and welcome to the Appeals Court. I am Chief Justice Amy Blake. To my right is Justice Christopher Hodgens. To my left is Justice Robert Toone. We are your panel for the 6 cases that will be heard today. We're using a little technology this morning, so just to get the lay of the land for those in the courtroom, our first 2 cases are going to be conducted hybrid by special order of the court. So what that means is that the Commonwealth is here in person and defense counsel has asked to appear remotely, and we've allowed that. The one thing that, just to remind you, counsel on Zoom, I understand that you've already sort of done a sound check with our staff, which is wonderful, but just, you will not be able to see the timer, so I will have the opportunity to remind you from time to time where you're at in terms of the 15 minutes, but if you also want to sort of keep a timer going as well so that we can cross-check each other, that would be great. Generally, for purposes of everyone in the court, as most of you know because you've been here before, each side is permitted 15 minutes of argument. There is no rebuttal at the appeals court. I can assure you that we have read all of your papers, so it's my best advice that you get right to the heart of your case. And with that, I will call the first case, which is partially impounded. So counsel, I'll remind you that it is Commonwealth versus John Doe, so we will not be using the defendant's name. The docket number is 24P397. Mr. Noonan, when you're ready.
Thank you, Chief Justice Blake and Justices of the Appeals Court. May it please the Court, Patrick Noonan for Mr. Doe. I did discover something that was very important to this case as I was preparing for it, and if you could just indulge me and give me a couple of minutes just to explain my discovery, and then feel free to dive in with some questions. So the claim here is that Mr. Doe is entitled to expungement because he was convicted of something that is no longer a crime. He was charged with carrying a firearm without a license, and he was in possession of an FID card, an LTC, that was expired at the time. Now, what I found was, at the time of his arrest, Chapter 140, Section 131, states that if you have a firearm license issued, it's valid for 5 years from the date of issuance. So in this case, Mr. Doe had his LTC issued in April of '91. So under the law back then, it would have been valid for 5 years, which would have been 1996. So he still would have had an invalid license because the arrest was in 1997. So that is the law back then. The law had changed in 2004 in the same statute, Chapter 140, Section 131, which states that your LTC is valid for 6 years from the date of issuance. So if you look at the exhibit with his firearm license history, it was issued on 4/18/91, and under new law, it would be valid for 6 years, which would bring him to April 18th, 1997. And his arrest was in January of 1997. So under the new firearm licensing laws, he would have been in possession of a valid license to carry, and therefore no crime would have been committed. So I would just refer the court to the chapter and section that I was referring to, which is the Chapter 130. Chapter 1.
Aren't we looking at the date of complaint was January 8th, 1997? Mm-hmm. Aren't I looking at what was the law at that time?
I think you have to look at what the law is now, because if what we have here for offenses that are no longer crimes is something that's a newer law, like the decriminalization of possession of marijuana, and that's the most popular that's the most popular basis for expungement. Because if someone is convicted of possession of marijuana under an ounce, back then when it was illegal to do that, and the law has changed to say it's now
carrying a firearm without a license is still a crime.
It is, but right now, the Commonwealth has to prove beyond reasonable doubt that he weren't licensed. Right, and he was validly licensed back then, so under
He wasn't
Guardaro.
validly licensed back then, but you want us to look, and you agree that in 1997, when the complaint issued, his license had been expired for roughly a year, but
Yes.
you're asking us to say we now need to look in 2025 and see if in 2025 his expired 1996 license, although expired, still met the statutory requirement.
Yeah, so if you take everything back then where he was 300 plus days expired, I think where we're looking at the expungement law, if you look at what the law is today, and if it is no longer a crime under those set of facts, then he is entitled to expungement, I believe. It wouldn't be a motion for a new trial because you're not applying the law back then. It would be a motion to expunge for not committing a crime now under the new laws.
All right, so let me ask you a different question about the statute, which is, would you agree with me that there was no evidence in this record that your client had applied to renew his license to carry before it expired?
Yes, in his affidavit, he doesn't say that he applied to renew it, and I know that.
Can I make the opposite inference? Can I make the inference that he did not?
Yes, he did not. He did not apply to renew it. And I know the Commonwealth is saying that that's a requirement, but I would disagree with that because you have the jury instructions, which is consistent with Commonwealth versus Farley and Commonwealth versus Indrasano, which say that that exemption is available if the person is not disqualified, they don't have any of the 7 disqualifiers, and they haven't had a license suspended or revoked, there's no revocation or suspension pending, and there's no application for renewal that was filed and denied. And in Indrasano, the appeals court said that the jury instructions in that case were proper, and the judge instructed the jury that the defendant is entitled to the criminal exemption if his license to carry was expired and he had not sought renewal of the license. So I don't think it's required for him to actually submit the renewal application because it gets into the fact that, people are entitled to the exemption if they become invalid inadvertently. And what I would say inadvertently is, forgetting to renew it, right after. And it was about 300 days or so that he inadvertently forgot to renew it. So if you look at Farley, Indrasano, and the jury instructions that are applied, he sets forth everything. He tracks the jury instructions that he had no disqualifiers. I'm sorry, Judge.
The model jury instructions can't trump the clear language of the safe harbor statute, can they? We have to look to the statute if we're trying to determine whether or not this would still be considered a crime. Don't we have to look at the statutory language?
Yes, you definitely have to look at the statutory language, but that statutory language was available in the Farley case and the Indrasano case. And in those cases, those 2 individuals did not, factually in those cases, did not submit renewal applications. So they had the statute on the books in Farley and Indrasano, and I don't think the court looked at it and didn't say in either case that it was a requirement to submit a renewal. And it doesn't make too much sense to me when it says that you are available for the exemption if your license becomes invalid inadvertently. I think of inadvertently, the most common way to be inadvertent is you forgot to submit the renewal application within the scope of your license. I don't really see anything else that would fall into the category of inadvertent. You're either disqualified, you have already been suspended or revoked, or you have a revocation that is on the book. So I think that the most common way it becomes invalid is forgetting to submit the renewal within your period of time to do so.
The Commonwealth seems to make a good point when they say your argument here indicates that once a person is granted a license to carry a firearm, they can never be charged with unlawful possession of a firearm going forward, regardless of whether that license becomes invalid.
Yeah.
Do you agree with that position?
I think it's a very interesting point, and you know, in Indersano, the defendant in that case had a license that expired in 1998, and he was arrested in 2009. So that was quite a gap in time, but the court still found that he met his burden of production to give him the affirmative defense to shift the burden, even though it was quite a gap in time. We were only dealing with 300 plus days here, but I understand what the Commonwealth is saying. You know, with a situation, it's like, well, somebody's had an expired license for like 20 years or something, and they still be entitled to the exemption. But I think the main thing that this statute is looking at is, let's say somebody has a long period of time where it's been expired. I think the main thing the statute is concerned about is whether that person has had any disqualifiers during that period of time. If they were convicted, they had a 209A, or they were committed to an institution or something like that. So I understand the Commonwealth's point, but I would just disagree with it on that, on the basis that I was saying.
I have another question for you. Counsel, you say that, I believe, at page 27 of your brief, that the Commonwealth took no position on your client's motion for expungement. But when I look at the record at page 32, I read the Commonwealth to say, and I'm quoting, "Your Honor, the Commonwealth takes no position and would defer to the court's discretion on this matter." I think if they had stopped after the Commonwealth takes no position, period, I would agree with you. But I don't see how then saying I defer to the court's discretion is taking no position or waiving, if you will, in some way, the argument here. So can you address that?
Yes, I think it was. I mean, it's deferring to the court's discretion. I think it's just, we take no position. It's like, well, just whatever happens, happens. You know,
Well,
I would.
no, it's we take no position and defer to the judge.
Right. I mean, I would just
Judge,
say.
you make the decision, and whatever it is, it is.
Right. I think that just to take no position, I just thought was just, those words itself were very strong for me to just think that they just were not really, you know, contesting this, and really just didn't really care too much if the court had allowed it.
Well, it's a little different, though, than the language in Commonwealth versus KW that you cite. That was sort of an unequivocal we take no position, particularly because the possession of marijuana in that amount was no longer a crime.
Well, I think the court can give it whatever weight the court wishes, you know, with regard to what the Commonwealth said at the hearing. The Commonwealth can say, well, if Your Honor wants to view it differently, that's totally fine. But also, I would say that the probation department took no position either. Usually, they have. Arguably, probation has just as much, if not more, of an interest in not having records expunged and having it on their record, and they took no position. So I would say, you know, coupling the two, Commonwealth and probation on taking a position, that I think that carries some weight for the court's consideration.
I just want to let you know you're at about 3.5 minutes remaining.
Well, I have no other. I have no other issues. If there are any other questions, I would.
Checking with the panel, it appears not, so we will happily take the rest of your argument on your brief. Thank you very much. Attorney Palumbo, good morning.
Good morning. May it please the court, Karen Palumbo on behalf of the Commonwealth. I'll dive right in. The question for the court below was whether or not possession of a firearm with an expired license is still a crime, as it was in 1997 when the defendant was convicted. The defendant refers to Farley and Indersano, both of which rely on statutory language that was in effect in 1998. In 2014, the statutory language was changed, and Chapter 140, Section 131M, currently reads as follows: notwithstanding the provisions of Section 10 of Chapter 269, any person in possession of a firearm, rifle, or shotgun whose license under this section is invalid for the sole reason that it has expired, not including licenses that remain valid under paragraph I, because the licensee applied for renewal before the license expired. It's a very limited exception or very limited safe harbor. And I believe that the language of the statute is unambiguous and clear as to the intent of the legislature. And also in relation to the legislation as a whole, it would be an absurd result that once you had acquired an LTC, you never had to renew that license again, as long as you weren't disqualified or suspended. So I would suggest that the judge properly denied the motion for expungement under 100K 2A2 because the crime today still is, it still is a crime. The defendant makes much of the fact that the judge didn't go on to discuss the best interests of justice. However, the court below was only required to do so if they found that one of the A1 through 6 factors applied. And the judge clearly found that possession of a firearm with an expired license is a crime. So I would suggest that the defense argument fails, and that this court should affirm the denial of the motion to expunge.
I have two questions.
Sure.
I'm looking at R34, and I get that it's a form and how busy it is in our district courts. Should the judge have said more?
I don't believe so. I think she said all she needed to say. She said, the defendant asserts that the offense is no longer a crime. The court disagrees. After review of submissions, arguments of the parties, and relevant case law, the petition is denied. I think that's absolutely sufficient, especially because it was a reason-based expungement, and that was the reason. And she clearly disagreed with it and found that the law is opposite.
All right, and so my second question, and it's I don't know if it's more of a practice tip or a question. The Commonwealth's position here was as vanilla as it could be, which is not particularly helpful on appeal. So is it the office policy to take no position? Do you have a sense of that?
Honestly, I'm not sure about that, but I would say that had the motion judge allowed the motion to expunge, we would not be able to, appeal it to this court and say this is the reason. But we deferred to the judge's discretion. The judge denied it based on the state of the law and the fact that possession of a firearm with an expired license is still a crime.
It just seems to me that going forward, we're starting to see more and more questions under the expungement and sealing statutes. We have our new firearm case law yesterday out of the SJC. It just seems as a matter of practice, it would be more helpful on appeal to understand the government's position a little bit more.
Okay, I will send that information back to our office.
Not shooting the messenger.
No.
Well, it would have been helpful to the judge, too, to have the argument you're articulating here stated to her. It's like, oh, this safe harbor exemption actually doesn't apply for this reason. It's
Correct. Yes, Your Honor.
Actually, what is the reason for deferring to the judge? Is it saying essentially, yeah, we're okay with it if you want to allow this, judge, but we just don't want to go on record as saying that? Is that?
I really don't know the answer to that, Your Honor. But I would suggest, and I will suggest to the office that in future motions for expungement that the Commonwealth take a position with respect to that. But again, the judge made the decision based on the law and correctly decided that the motion should be denied. If there are any other questions?
I don't see any. We'll take the rest of your argument on your brief. Thank you very much. The case is under advisement.
Thank you.
And Attorney Noonan, please keep your video on even when the other side is arguing. That would be helpful. I just need to know you're still there and hearing everything.
Will do. I heard everything.
Oh, great. All right, I'll give counsel a moment while we get ready for our next case, which is Commonwealth versus Louise Johnson, docket number 24P65. Now, as counsel gets set up, a reminder that this case is partially impounded. I know that the appellant's brief is impounded. I was concerned because the victim's name appears everywhere in the brief. So I just want to be clear, no victim's name during oral argument. Everybody understands?
Yes, Your Honor.
Okay. So, Mr. Noonan, when you are ready, the 15 minutes will start.
Thank you, Your Honor. And also, thank you for allowing me to appear by Zoom today. I really appreciate it. I really want to focus on the required finding in this case. And I think that the evidence that my client is the person who committed these offenses back in 2001 and 2002 was very speculative. The jury would have to engage in lots of guesswork, and it would be inference piling. And I think the most compelling evidence of my client's innocence, or the Commonwealth's failure to prove the case, was the Commonwealth's own witness, who was Joanne Fay, the COO of the camp where this supposedly occurred. And they called her for the specific purpose of trying to establish that my client and the alleged victim were at this camp at the same time during the same summer. And I would suggest that Ms. Fay's testimony was very persuasive, because not only was she the COO of the camp, but this was a camp that had a $5 million budget and was a 501c3 charity, and they had to keep payroll records for their employees to submit to the IRS. And she did say that the records that they kept were in good working order. And
why doesn't that all just go to the weight of the evidence? I mean, that doesn't sound like a sufficiency argument. That sounds like you're arguing the weight of the evidence.
Well, I would say that I think that when you look at that evidence from Ms. Fay and those records, it does not square with any of the evidence that was also presented by the Commonwealth, where they put in a witness, Ian Morehouse, who tried to say that, he saw my client at the camp in 01 and 02, but, his testimony can't be reconciled when he's saying, well, it's definitely, the defendant here in a photo in 2001, where it was clear that the defendant wasn't even there in 2001 and was in New York. So I would say on their ability to prove the case at a required finding stage, that's only one component of it, is proving that he was actually there at the same time of the alleged victim. And I think the other part of the sufficiency argument is, whether the evidence they presented was enough to identify my client as the culprit altogether. And in the alleged victim's testimony, I think it was just highly speculative that it was my client. There was no in-court ID by the alleged victim. And when he looked at this one picture, and the court can take a look at that picture that was submitted into evidence, the picture is very poor quality, and the alleged victim states, I thought it was him in the picture. I'm not positive it was him in the picture. He said, well, it's been 20 years. I'm not sure if that was exactly the person I remembered.
Well, the identification, that can be proven circumstantially, right?
Yeah, absolutely it can.
So you don't actually need someone in court to, point to somebody and say, that's the guy who did it. You can still prove it otherwise, right?
Absolutely, Your Honor. I would just say that the totality of the evidence presented by the Commonwealth here, I don't think a rational jury could conclude beyond a reasonable doubt that it was Mr. Johnson that committed these offenses. When you look at the camp records, and you look at the testimony of the alleged victim, who has no real certainty whatsoever that it's my client, saying I'm not even positive, I don't think it's him. And then you bring in Ian Morehouse, who I think was the Commonwealth. I think the Commonwealth was trying to look to him as their saving grace. He really didn't offer too much that I think was persuasive for the Commonwealth's ability to survive a required finding. He comes in and he says, well, you know what, he's in a picture in 01, and I think I saw him there in 01 and 02, but at the same time, Ian Morehouse had no conversations with my client ever, never interacted with him. Never even had a conversation with him. And I just think that no rational jury can conclude, based on this evidence, that it's my client who was there that committed these offenses. It's just highly speculative. And in Morehouse, I don't think he offered much of anything. I don't know how he can come in and a jury can say this is a good ID when he's had no conversations or interactions with this fellow, and it's been over 20 years since the incident and the trial. So I'm just resting on all of the evidence presented by the Commonwealth is just not sustaining their burden on a required finding.
Can I just, so we're clear about what we're deciding, Are you, in view of the allowed motion for new trial from the trial judge, are you pressing on appeal your grand jury claims or only pressing the sufficiency claim?
I think the sufficiency claim, obviously, I have, the most interest in doing that, because if it's allowed, obviously, then there's no new trial. But I think that the court still, has an interest in reviewing the integrity of the grand jury proceedings, just as a matter of.
But if you're getting a new trial, isn't that for the Superior Court judge?
Well, if this court finds that the integrity of the grand jury proceedings were impaired, then at the Commonwealth could, it could be a dismissal with prejudice depending upon the court's finding of the Commonwealth's impairment of the grand jury. But if there is a finding that the integrity of the grand jury was impaired and they went to re-indict, then they would have to, on a re-indictment, present the evidence I'm saying was exculpatory and should have been presented at the first grand jury, because by omitting all of the defendant's exculpatory statements distorted the presentation significantly. And if they're going to go re-indict, I think that they should be required to present that evidence, because it would have changed the grand jury's decision to indict completely. And that's the issue, is if they presented this, would this have changed the grand jury's decision to indict? So if they did, if they can go back and do it again, but I would just say that they would have to put that evidence in at a second grand jury.
But now, why would we review something that might only be an academic exercise? In other words, if this goes back, which it is going back for a new trial, and let's say the defendant's acquitted, but in the meantime, we've gone through the record and we've determined that either thumbs up or thumbs down with the grand jury presentation, what sense would that make? Doesn't it, in terms of just judicial resources, isn't it better to await to see what happens at a second trial to see if we even have to address the grand jury issue?
Well, I would say two things. I would say, one, that the court's resolution of determining whether there was an impairment of the grand jury, I think is kind of a straightforward type of question. Just based on, I only cite two cases, Odell and Ferrara, which were cases that where the Commonwealth put in statements of a defendant and then omitted statements which distorted the grand jury. And then here I'm just making the same argument. So I think that the court's sort of, resolution of that issue, in an opinion would, I don't want to make the court do work that it doesn't need to do, but I think just addressing it wouldn't take much by way of, it's not pouring through, like thousands of pages of grand jury. The grand jury, I think, was, only about 25 pages or so, and there were really no exhibits. And then I would say that the defendant's right to, a grand jury proceeding with integrity is a constitutional right under Article 12. So I think the court also just has, an interest in ensuring that these proceedings are done fair and impartially.
You have about 6 minutes and 20 seconds.
Okay, so I would just move on to the last issue, which is, the probable cause issue for the grand jury as well. And there is, in the law, and especially under the Fourth Amendment, the defendant has a right to a finding of probable cause at a grand jury, so that the grand jury can fulfill its traditional function of effective protection against unfounded criminal prosecution. So if this court were to find that there was insufficient probable cause presented at this grand jury, then the Commonwealth would have to reconvene a new grand jury with the burden of producing probable cause at a new grand jury. And I think that the evidence presented at this grand jury, again, to identify my client was I don't think met the level of probable cause. The alleged victim gave a very limited description of the suspect, saying it was a black male. However, the detective who testified never met the defendant and couldn't say what his race was. and the alleged victim stated that the suspect was chubby. Again, the detective gave there was no physical description of my client. The alleged victim gave an age for the culprit in the 20s or 30s, but there was no evidence of the defendant's age. There was no identification of my client. And I understand that, as Justice Hodges was saying, we can prove identification circumstantially, but I just think that what we had here at the grand jury with no physical description of the defendant, no photographs of the defendant, no R&B photographs of the defendant, no identification of the defendant. All we had was we had a Lewis from New York back in 01 and 02, and that was basically the only links that they had. So I would say they did not meet probable cause, and if there are no other questions, I would rest on my brief.
Counsel, I don't see any. Thank you very much.
Thank you.
And
I'll keep my camera on.
Thank you. Who will be arguing for the Commonwealth? Ms. McKinnon? Yes. Wonderful.
And if it may please the court, Assistant District Attorney Molly McKinnon on behalf of the Commonwealth. Your Honors, respectfully, from the Commonwealth's perspective, this defendant got a new trial. I think that's really the crux of the Commonwealth's argument that we had articulated in our brief is that this defendant received a new trial.
But don't we still have to review sufficiency?
Your Honor, the fact that he got a new trial, I think that negates the issue of looking at this case for a matter of what he's looking for is under the 25B2 rule.
So if we review the record and we determine that the evidence was insufficient, Commonwealth still gets to retry him?
I would say, if I may just ask a question in return, just so I'm answering it appropriately, are you looking at from a perspective of a double jeopardy argument?
Right,
Okay.
Exactly.
So, Your Honor, from that perspective, well, if I may, just for one moment. So, yes, double jeopardy does require sufficiency, that for in order for the Commonwealth, but the thing is that here, it's my understanding from the case law is that once a conviction is vacated, the Commonwealth can proceed so long as there's sufficient evidence. But what counsel here is going after, he's going after the 25B2 motion for a trial that was vacated. And that's not what's before the court from our perspective is he's trying to essentially take the trial that was vacated and try to essentially get another, from using his words, another bite at the apple to try to have this case dismissed going by the avenue of the 25B.
Well, he's trying to get a review of the denial of his motions for required findings, right? And that's not covered by the decision to vacate the convictions. That's sort of a live issue. So it seems to me that there is something that we may have to review here because if we were to conclude there wasn't sufficient evidence to support the conviction, that seems to be something we need to decide so that he doesn't have to be retried. Wouldn't you agree?
Again, and I can get into the sufficiency in a minute. I think just based on what he's going after the conviction of this trial. Yeah. So that's really a part of what we're harping on. But if I may, with respect to the matter of sufficiency.
Before you go there,
yes.
So are you saying that we would be in a different appellate position if the motion for new trial had not been granted? If this was a direct appeal of a conviction under the rule, we would be reviewing sufficiency.
I would say if that was the basis, yes, because that's the thing, we don't have a conviction here.
Okay.
That's really what we're trying to articulate is he got a new trial. So from our perspective, where this matter should be heard, it should be, I think the proper mechanism here would be for defense to file a motion to dismiss potentially under double jeopardy claims in the trial court. From our perspective, this matter is in the trial posture and should be heading in that direction at this point.
And without going too far outside the record, I assume the proceedings below are stayed or pending our resolution.
That is correct.
Okay.
That is correct.
But here's the problem I have with that, just as a practical matter, and I think I would certainly agree with you if the issue of sufficiency hadn't been raised. So in other words, if the posture of the case was a little bit different and it came to us without a sufficiency argument being raised, and the judge had allowed a motion for a new trial, it was going back for another trial, I'd agree with you that it should just be tried again in the usual course, and if it gets to us, it gets to us after that. But this is a little bit different because there was a sufficiency argument that was raised, and it hasn't received appellate review yet. So it would seem unfair to then send it back, have the defendant endure another trial, only for us to then later say, oh, gee whiz, it looks like the evidence really wasn't sufficient. He shouldn't have had to have stood trial a second time. So he would have actually been subjected to double jeopardy, and we could have stopped it from happening. So it just seems as a matter of fairness that if he's raised the sufficiency argument, we should take a look at it, don't you think? To avoid putting him in jeopardy?
I think, again, I think just based on the mechanism that defense has filed, it's under the 25B2, and looking at the rule here, it's after the case has been submitted to the jury and the jury has been discharged. I think I'm just trying to look at specifically the rule here that's being presented, and that the fact is that, yes, the jury had returned a conviction, but then that conviction was vacated. So we're essentially back to square one waiting for a trial to happen. So I think from that perspective, and I apologize, and please let me know if I don't answer your question. I want to make sure that I do, because I mean, I would agree, it's an interesting position, but from where we see it, from the Commonwealth's perspective, is we had a trial, they came back, they were convicted, and then then that conviction was vacated. But then after defense had filed the 25B2 motion, but then again, afterwards, it was vacated, and looking at what 25B2 says, that it can either be that 25B2 motion, or it could be a motion for new trial, if I'm understanding the rule correctly. So, I mean, those are sort of the two options, and he got a new trial. So, and please let me know if I'm not.
Let me try another option. What if we did nothing and just said, well, it's teed up for another trial, so let's just see what happens. And then the defendant says, well, wait a minute, I really think I'm going to be put in jeopardy here yet again. I'm going to file a 211-3 petition and take this to single justice. And then the single justice looks at it and says, it seems to be something here that this sufficiency of evidence issue really should be ironed out before you're put to trial again, and then it gets referred to the appeals court to decide.
Right.
I'm just thinking, as a practical matter, it's here with this lingering question of sufficiency. Isn't that something that we should resolve before he's put to trial again?
I would still say, I still think just given the posture of the case, I would say no. I mean, defense, like as I indicated before, I think defense could, that the proper mechanism is potentially a motion to dismiss in the Superior Court, which I understand that he could obviously appeal and could come back here. I mean, that's obviously the way that the process works. But in any event, I would just to be conscious of time, I can just articulate just sufficiency just to address it and have it on the record, if I may. Okay. Your Honor, from the Commonwealth's perspective here is that the named victim had come forward. He'd gone to the Duxbury Police Station and had indicated that a individual at the camp who he had known as Lewis was an individual who he remembers him being from New York, from his perspective, he was around 10 to 11 at the time based on his memory, had gone and remembers this individual being older from his perspective, somewhere between 20 to 30 years old, wore very gaudy jewelry based on his memory, and he had hair in cornrows. That's not a full perspective of he didn't testify to all of that at trial, I believe. I know he had indicated that he remembers that this individual was Lewis, wore gold jewelry, was from New York, and remembers him being a very strict camp counselor. That was some of the memories that he had of this individual. There were, based on the records that were obtained and through the testimony of the camp's chief operating officer, is that based on the information that they looked for with the timeframes, and this was something back before things were digitized, so they were Rubbermaid buckets that they were going through, essentially hand searching for records, and based on their memory, there was only one Lewis. And I think that is significant, the fact that there was only one Lewis who was a camp counselor at the camp during that time period. And based off of that, they are able to obtain a file. And I think this is obviously an issue, what Your Honor had said earlier about the issue of weight. It's an issue of weight on whether or not the jury wanted to credit whether or not they were able to find all of the records, just given the system that was presented at the time. It was hand looking through everything, and I know that's ripe with human error, and the jury took it for whatever weight it was worth. There was testimony from Mr. Morehouse, who was able, when speaking to the named victim, when they were having a conversation about this individual named Lewis, he was able to go right away and pull up a picture from an individual who he believed to be Lewis. And it's my memory, and I can always afterwards, I apologize if I am misstating the evidence, but he was able to go and pull up a picture of an individual who was a black male, heavier set, in a camp counselor group photo from around that time frame. And he remembers he wasn't the direct supervisor of the defendant, but he remembers interacting him. He had that memory. I mean, the memory being where he was able to pull up a picture so quickly. And again, that was an issue of weight for the jury to decide whether or not they credited that testimony with that picture. Further, the file that was obtained for the only Lewis at that camp was for an individual who resided in New York. And it was with that information that the detective was able to call and spoke to the defendant, who admitted that he had been at that camp around that time period. So I think, given the fact, yes, it is circumstantial, but circumstantial evidence is evidence, as we all know. But those puzzle pieces essentially together, I think, create the sufficiency that, looking at the light most favorable to the Commonwealth, shows that these incidents lead up to what had happened. I mean, obviously, I'm not getting into I know the crux of the issue from defense is the portion of identification, so I won't get too much into the actual charges, but I think from that identification perspective, I think the Commonwealth was able to show that it was this individual who committed these acts against this child. So I think from that position of Lattimore, I think, like most people of the Commonwealth met that burden in terms of sufficiency. And so.
Can I just ask a quick question about the indictment challenge and the Odell issue?
Yes.
So the trial judge already rejected those challenges to the indictment, correct?
Correct.
So assuming that we conclude, well, we're not going to review that piece of the case, does the defendant get to renew his challenge to the indictment going back, or is that the decision of the case that doesn't get looked at again until, in the event that the defendant's convicted and comes up in an appeal again?
So
Is there a fresh look at the indictment issue, or is it your view that that's already been decided?
I would say that our position is that it would have to wait until after the conviction. I think that's my understanding of the rules, and obviously I could be wrong, but that's my understanding.
From our perspective, right, but I'm saying, can the defendant file a new motion challenging the indictment?
In the terms of the Odell issue?
Under the Adele issue, right? Or does the defendant have to file a new motion? It's a different question.
That is, both are, I know I'm going, I was trying to think when now it's coming down to the crunch time, I'm so sorry.
That's all right. Your best answer is fine. I'm just curious as to whether that needs to be renewed or not.
I mean, I can't speak for defense on what their position is, and I mean, I would say that I think since it's already been decided by the trial, in the Superior Court, I mean, I think that and obviously it's our position that that judge was correct in it, so I think that issue has been addressed, and then if, we go to trial and we're successful at trial and there's a conviction, then that would be an issue to come back before the panel to determine whether or not that was an issue.
Let me just make sure.
Good, thanks.
All right, I see no further questions. We will take the rest of your arguments under advisement. Difficult case, great arguments from both sides. Thank you very much. It's under
Thank you
advisement.
very much.
Thank you, Your Honors. Appreciate it.
We're not going to leave the bench, but I know we need a brief moment to disconnect our high-tech system here. So I'll ask the lawyers to come up on our next case, Commonwealth versus John Michelin, 23P 1322. And Ms. Fisher, you'll let me know when you're ready to go on the technology. For counsel in the room, we're likely going to take a brief morning recess after this case, and shouldn't be more than 10 minutes or so. All right, on the Michelin case, counsel, when you're ready.
Thank you, Chief Justice Blake, Justices Toone and Hodgens. Good morning. Attorney Terry Treviakis for Mr. Michelin. May it please the court. With regard to the issue of whether the warrantless entry into the apartment was justified, I'd first like to address the Commonwealth's, in the Commonwealth's brief, there was a challenge whether the defendant had an expectation of privacy in the apartment. And I would note that if you read the motion judge's decision in his findings of fact, he acknowledges the issue in terms of the defendant and the victim having they were overnight guests essentially in the apartment. Number two, the Commonwealth didn't raise that issue below. Number three, the judge didn't flag the issue in his findings of fact and rulings. It was, if you read the decision in totality, he acknowledges basically that there was an expectation of privacy. But I would also note that, in particular, there was, in fact, evidence of that Michelin was a overnight guest. His taped interview, his recorded interview, was admitted into evidence at the motion hearing, and within that interview, he tells the police that he had been staying there for the last few nights. So, in fact, there is evidence that Mr. Michelin did have an expectation of privacy. Now,
But even if he did, help me with there's a person laid out and what the police are supposed to do under what I would describe as those exigent circumstances.
right. So the information that was known to the police, number one, they respond, they're outside, and they speak to Mr. Hilliard. Mr. Hilliard has an injured finger. He tells the police that guy struck me with a baseball bat, essentially, and there's somebody laid out. So the police enter the common area of the hallway, and outside the apartment door, they find the victim who's has apparent injuries, he's bleeding, and he's unconscious. That's the only information known to the police. And with regard to exigent circumstances.
And so, wait, pause. And the police at that moment are supposed to do what?
Number one, call the ambulance and get him help.
And then just stop and get a warrant?
Well, Really, yes. I mean, at that point, they have no other information.
Right, so let's say that that's exactly what they were supposed to do. Don't they now have to preserve the scene, make sure that there aren't any other people that are hurt, any other aggressors, all while securing the scene while someone applies for a search warrant?
Right, so the scene, as they know it at that time, is the common hallway.
You think it's just the hall?
Well, that's the only evidence and information that they have. Mr. Hilliard didn't tell the police where the person was laid out. He just said a guy's laid out. And when the police went to the common hallway, they then saw the victim in the common hallway on the ground.
Are you challenging the entry into the common hallway?
No.
You're not? Okay, so even though they had to kind of shimmy the door open and get in, you're saying that's not a Fourth Amendment issue? It's
Right.
only once they get in, see the body, and then enter the apartment. That's where your Fourth Amendment claim starts.
Correct. I mean, I would think it's a common hallway. There's no expectation of privacy in the common hallway. As I understand it from the evidence and the layout, the common hallway was accessible to anybody in the unit. I'm not, that wasn't raised in my brief.
So then it's the statement from Hilliard about the body laying out, getting in, seeing the body there. That's kind of the nucleus of facts that we're dealing with to sort of
Correct.
say, was there enough to justify entry? And so there's kind of exigent circumstances, which is responding to a potential, I guess, potential assailants running around, and also emergency aid, that there might be other victims inside. Those are kind of the two justifications that were relied on.
Those are the two justifications relied upon by the Commonwealth, and what the motion judge found that I would respectfully submit were not justified. Because at the end of the day, when they enter that common hallway, yes, they do see the person, quote-unquote, laid out in the common hallway. That's all the information that the police know at that time. They have no reason to believe that anybody else within the apartment might be in danger or injured. They have no reason to believe that there is an inherently dangerous weapon involved. Although it's true that that Hilliard told the police that men were armed with a baseball bat. A baseball bat, as you know, is not inherently dangerous. There was no report of a knife or a firearm being used. And so my assertion is at that point, once the officers tend to the victim, even with information from the other officers that had observed movement within the apartment, there was a police presence that have responded. There was no risk of flight. There was.
Oh, but wait a minute, before you even get there, in the findings of fact, the judge said, but eventually he related that there had been a fight inside the apartment.
That was prior to, as I understood that evidence was that there was a fight into the apartment, which, with regard to Hilliard, and then Mr. Hilliard came out, called the police, and then the only other information was that there was a person laid out. So there was no subsequent evidence or fight within the apartment after Hilliard left.
Well, isn't that enough? I mean, there's been a fight in the apartment, someone's wielding a bat, he's already struck somebody who's called the police, summoned them there, and then he's told the police there's a fight in the apartment, and there's someone, in addition to me being injured, there's someone laid out. And you're suggesting the police should not enter the apartment, that they should just stand by?
I think it'd be a different situation if when they entered the common hallway, they did not see anybody. And then they would have had reason to believe that the person laid out was in the apartment. I think that's a completely different contextual scenario of events, that if that were the case, then I would have.
But isn't it worse that they found a second victim who was in dire physical situation compared to Hilliard outside with the finger? I mean, now it's an escalating crime scene, isn't it? You have two victims instead of one. You have one who unfortunately subsequently dies.
There were always two victims. Hilliard conveyed to the police there were two victims.
Because someone was laid out.
Himself and the person.
We don't know what that means
Right.
in that moment.
Right.
They then make the observations, and it sounds like it was a pretty gruesome scene. To me, that escalates the exigency and the need for emergency aid and the need to enter. But I hear you arguing that it it doesn't, and I'm struggling with that.
I'm not necessarily saying that it does not completely, obviously, it's a factor to consider, but with regard to exigency and the emergency aid doctrine, the police have to consider the totality of the circumstances, of course. So it's the knowledge of the police officer at that moment, when they come across the victim in the hallway, what else do they know? They don't know anything else. They have reason to believe that the suspects are in the apartment, but even were there, even if there were probable cause to believe that the assailants are in the apartment, that alone is not enough to justify the warrantless entry. You still have to analyze and consider the other factors: risk of flight, risk of destruction of evidence, and those are factors that the police simply did not have any.
But I'm not even sure you have to get there. If you've got someone who's already been injured, he's called the police, he said someone's laid out in the apartment, there was a fight in the apartment, the police enter this common area, they see this poor guy at the bottom of the stairs, clearly beaten, bloodied. They don't even know if this is the person who was laid out in the apartment. There could be yet another body that they're going to come across.
Well, that I respectfully would submit would be just conjecture and speculation. They don't know. They don't have information on that.
But shouldn't they find out?
Well, what did? They knocked on the apartment door, and rather than, Stevens opened the door, the co-defendant, and rather than inquiring, they immediately arrested him and then entered the apartment. They simply did not have the information to determine one way or the other at that point what could have been in the apartment, if anything. My suggestion is that the officers, 6 to 8 police officers, I believe had responded by that point. There was, again, no risk of flight. They couldn't know whether there was any evidence within the apartment that might have been destroyed or removed or whatnot.
Can I ask you about, at Record 93, Judge Lang says, quote, a delay caused in obtaining a search warrant would have presented, quote, a greater risk to the officers, as the suspects would have had a greater opportunity, if so inclined, to further arm themselves and prepare to try to repel the eventual police entry. Therefore, the police entry was supported by probable cause and exigent circumstances.
Right.
So taking the focus for a second off of potential other victims, what about the safety to the police officers?
Well, again, where is the evidence that the suspects within could have further armed themselves? The officer, again, there was no allegation of a firearm being used.
Had they found a weapon before they entered? You see a very bloody scene. Had they found a weapon? No.
No, but they didn't know. They came across a bloody scene, but they didn't know at that point what had transpired in terms of the full extent of the injuries. They pieced it together after the fact, in hindsight. But at the time when they first entered, all they see is a person unconscious with blood around his body. They didn't know at that point, or they didn't believe that he was the degree of his injuries. They didn't know that at that point he was still alive. They didn't know how the injuries happened. I think it would have been a different scenario had Hilliard perhaps indicated to the police that the assailants inside had a firearm or a knife or some other dangerous weapon of that sort.
Well, out of respect to the deceased, there was a lot more graphic detail that the police observed, right?
Absolutely.
This wasn't just a beating.
Well, I think, with all due respect to the victim and really the circumstances of the entirety of the case, the focus, and I know it's...
I raise it in the context of what the exigency was in that moment. This wasn't a fist fight. This was something much bigger. And you have the gentleman outside, you have the state of the victim and the state of his body.
We know that now after trial, but at the time the officers entered the hallway, respectfully, they didn't know that. They didn't know it was anything more than a fist fight. And, I'm trying to parse out the facts.
I appreciate that.
And just focus on, it's really the focus, unfortunately, again, with respect to everything that ultimately transpired, the critical question and the difficult question to answer in this case, respectfully, is before they opened that door and entered, what did they know? And that's, if you isolate the facts at that moment in time, I think that's where you get into the issue, okay, did the officers have exigent circumstances? Did they have, were justified under the emergency aid doctrine? And respectfully, I would ask the court to find that they did not have those. I know my time is very short. I would just
Can I ask you to skip very quickly to the unanimity instruction?
Yes.
Are you saying the Commonwealth proceeded on more than one theory, and if so, what were those multiple theories? Because I didn't follow that.
So the crux of my argument is that there were, the allegations by the Commonwealth at trial were two, what I suggest are two separate events. One, there was evidence that Mr. Michelin held up the victim while he was being struck with a baseball bat by Stevens. There was evidence of that. I'm not disputing that. But the other issue, which I would respectfully submit as a separate and distinct act, is the issue with the broomstick and the other injuries sustained. And really, and this goes also into my argument of improper closing argument by the Commonwealth, there was no evidence at trial as to how those injuries occurred, nor who was responsible for those injuries. I understand, obviously, that the Commonwealth at trial is permitted to make reasonable inferences and rely on circumstantial evidence, but in the totality of the record, the only evidence that was produced by the Commonwealth and for the jury to consider was simply that somehow Mr. Riley had suffered these internal injuries that resulted in his death, but we don't know, it can't explain who or how it exactly happened. And I think that's what distinguishes the Commonwealth's position in terms of a continuous episode. In this particular case, because we don't know how that episode occurred, that's why the danger in the specific unanimity instruction was prevalent, and the jury should have instructed the jury, because now the danger is, well, how did the jury convict the defendant? Did they, despite no evidence of him being involved with the broomstick, simply participating in the other injuries? If the jury were to accept that, that's the problem with
I do know your time has expired, but I want to check with the panel because we've asked you a lot of questions. It looks like we are all set for now. I know you had other arguments, and I assure you that we will take those on brief. Thank you.
Thank you very much.
Attorney Moriarty.
Good morning. May it please the court, Marina Moriarty on behalf of the Commonwealth. Your Honors, I would like to start with the point that counsel just made, that the police didn't know anything other than what Mr. Hilliard told them before they opened the door to that basement apartment, and that they then learned what the scene that they came upon, a bloody scene that indicated, I would suggest, much more than just an average beating. The police also observed, and I believe it was Officer Recupero and the other officers that testified, that as they walked down that side alleyway, they were making observations into the basement apartment. And as they made observations into the basement apartment, they saw at least two individuals walking together in and out of a couple different bedrooms. So they were able to corroborate part of what Mr. Hilliard said. Mr. Hilliard said there's 3 or 4 people with gang members that just had a fight with me inside that apartment. They attacked me with a bat, and they're still in there. So they knew that there was at least 2 individuals in that basement apartment. And furthermore, they heard the voices of 2 individuals as they were trying to jimmy open that back door, grunting, making moving sounds. Somebody said, just leave them here. So I would suggest that those factors also combined to further the exigent circumstances that were certainly prevalent in this case. I would suggest that Judge Lang's findings were entirely supported, and that his rulings of law are reasonable, and that there was probable cause, and that exactly as Your Honors asked, what were the police supposed to do in the circumstances? They knew that there was at least 2 people in that apartment. Either there was one assailant and a victim, there were two assailants, there could have been additional potential victims. In fact, they found a woman hiding in the bathroom. There just simply wasn't time to freeze the scene from the outside. And
Can I just ask, just to clarify, your position, I think, is probably the same as the defendant, that there's no Fourth Amendment issue posed by the jimming of the back door and entry into the common hallway. Is that correct? And if so, just tell me why quickly.
the defendant never raised that
Okay.
as an issue, and so I would suggest that it is waived. Additionally, I would suggest that the officers, and that fact that it is in fact a common area of which the defendant would have no expectation of privacy, even if he had an expectation of privacy in the apartment itself, which I suggest that is potentially an open question. But Officer Recupero testified he was familiar with that particular building. He was familiar with that back door. He knew the back door was easily opened, that the back door led down to the stairway, that there was the basement apartment, and then that there was a common area / maintenance room across the hall that was unlocked, that had motion sensing.
So we're just looking at one set of facts that includes Hilliard's statement, what Rusapero, if I'm pronouncing that correctly, heard, what they saw in the hallway. All those facts are what we're looking at in terms of the entry into the apartment.
Yes, I don't think the defendant has argued that any of Judge Lang's findings of fact are clearly erroneous. So I think that that is exactly what Judge Lang found based on what he deemed the officer's credible testimony to be.
And the Commonwealth didn't challenge the defendant's expectation of privacy below?
Correct.
Correct, okay.
It was raised for the first time on appeal. And I will agree that the defendant's statement was put in as evidence at the motion hearing. So that is also in the record at the motion hearing. So again, I would just suggest that these exigent circumstances, the police didn't know whether evidence would be destroyed. And in fact, there was evidence that when they went in, that someone was trying to clean up the scene.
Exigent circumstances is kind of this broad category, and I think emergency aid is a subset of that. So setting aside emergency aid, the possibility that there were other victims they need to assist, what exactly are the exigent circumstances? Just like what categorically?
In this particular case?
In this particular case, yes.
I would suggest that I don't think there's a dispute that there was probable cause to enter the apartment for evidence of a crime. So that's the first requirement for exigent circumstances. And then with respect to the factors, I would concede that the police had covered the only door to the apartment, but again, you don't know if someone might try to flee out of one of the windows. There's a concern that evidence may be destroyed, because I think that the officers testified that this was a fluid, ongoing, making decisions in the moment. So there is obviously concern that where there's an incredibly violent assault that happened literally just outside the door of the apartment, there's concern that there may be evidence that could be destroyed. And again, I think Judge Lane made the good point in his conclusions that there was at least one bat-wielding assailant in the apartment, and preventing the police from entering as quickly as possible could have allowed the bat-wielding assailant to then switch to a knife, to then find a gun. I don't think the police are required to stop and academically assess the situation. In fact, that's not what the case law says.
We have to, in some sense, right? But you're saying there's a risk of flight, potential for destruction of evidence, potential for other criminal acts being done, given this is continuous.
And although it's not in the list, in the Almoner list with respect to exigent circumstances, I do think that the fact that you have at least 2 victims and that there could be more is certainly exigent circumstances. It may also be under the emergency aid exception, which does not require probable cause, but I think also the fact that there may be a person in imminent danger is certainly an exigent circumstance, and it should be an exigent circumstance under the law. If there are no further questions with respect to the warrant issues, I will just touch on the unanimity instruction, or the lack thereof. I don't think that the judge was required to sua sponte give an instruction where one was not requested. I think the case law is clear where there are separate, distinct, and essentially unrelated ways in which the same crime can be committed, then a unanimity instruction is required. But here, this was not like separate episodes. This was one episode that, based on the trial testimony, happened within minutes. The beating, the assault with the broomstick, Mr. Hilliard's escaping the house and calling 911. I think that this was a continuing course of conduct conducted by both the defendant and the co-defendant in this case. I think it's similar to the cases I cited in my brief. Thatch, it was a digital rape followed by a penile rape, and the court in that case said that, and it was indicted as one count of rape and returned as one guilty count of rape. And the court in that case found that the jury did not need a unanimity instruction with respect to how the rape occurred. Again, there's a case I did not cite, but I found in my research, LaRory, it's 437 Mass 65. It's an assault with intent to murder, and there were multiple different assaults. And in that case, the court also found that the jury did not need to be unanimous about which specific assault was on which the conviction was based, because it was not alternative theories, it was all one factual episode. And if the court has no further questions, I'm happy to rest on my brief.
I don't see any. Thank you very much. It's a very
you.
difficult case, and it was very well argued, so I thank both of you. It is under advisement. We are going to take a brief morning recess, and the next case up will be the Don Doe Sorb case.
Close the session, please be seated.
Good morning again. Our next case is John Doe 527037 versus the Sex Offender Registry Board. I know council's well experienced in this, but the case is impounded, so please follow our rules with respect to that. Mr. Burkholder, good morning when you are ready.
Thank you, Your Honor. May it please the court. Relatively and low don't mean the same thing. And that's the start of my argument.
So you know my first question, right?
Yes.
Is there such a thing as a sex offender registry level 0?
No, there is not. And if the decisions, I went through them again this morning, even though they're cited in my brief, just to try to figure out, first of all, no cognizable risk was never actually enunciated by any court. It was Doe's argument in 1211. It's not even stated as this is the standard thereafter. It was Doe's argument, and that the case was decided that there was no, the risk was not nil, and as a result, the judgment was affirmed. The classification was affirmed.
So does the board have, does the hearing examiner have the ability to relieve somebody of their duty to register?
No. No, and they
Are there
still.
cases that say what a court can do to relieve somebody from their ability to register? And what is your best case?
24341. Basically, the board takes.
24341?
Yes, it's cited in my brief. Basically, the board took the position that under the statute, if you were convicted of a sexually dangerous offense that was sexually violent or otherwise, that you were precluded from relief from registration. And that remained the law, and they still follow it to this day. And then 8725 came out, and it said, wait a minute, due process is involved in this, and especially because a lot of these classifications were prior to the statute or the regulations being put in place in the statute, we need to take a serious look at this. And what they said was, we've got to base these on current risk. And as a result of that, then 24341 said, well, based upon that, then we can evaluate it, we can make a decision. And what you see is the decision still come out of the board that says, because it's the nature of the offense, it's an enumerated offense, it's sexually dangerous or otherwise, that we don't have the authority, and then you go to Superior Court, and Superior Court may or may not do it, but if you're going to get it done, it's there, to some degree, this court. That brings me to really my argument in the case, which is Doe 523671, which is the decision that says everything I need to say. I don't even need to repeat it. It says everything I need to say, and one step better in my case, my guy's going to be 81.
Right.
Number two, his offenses were 40 years ago.
But here's where I get stuck. So many of these cases, the hearing examiner discounts, rejects, pick the word, the defense expert. Here, and I want to check my notes to make sure I say it correctly.
Right. You're
the
right.
hearing examiner agreed with your expert as to the ultimate opinion.
No.
What am I wrong?
Relatively low and low don't mean the same thing. Relatively low means, according to Miriam, sort of. Doesn't mean the same. So as a result of that, then you get to the cases which try to define what in fact is required. In 24341, they state the term low must be given a reasonable interpretation. It should not be taken to mean anything more than no. And then you look at LL versus Commonwealth, and it says the following. Where is it exactly? It says, it kind of gets into the definitions that were provided in, here we go. Potentially subject to, moreover, there appears to be a consensus, no, that's the wrong quote. Let me find the right quote. Which dealt with the standard that was applicable, and it kind of said, it repeats the definition of, I can't even find it. Oh, here it is. Let me see. We do not interpret this language to mean no risk because the absence of any risk is impossible as a matter of logic and common sense. So basically what they're trying to say is, and why I'm here, nobody really knows. And then it becomes, the cases end up being a determination based upon the regulatory factors, and that takes us back to the same problem, which is how much weight to place upon these factors and the like, and that's where current risk becomes such an important consideration. I frankly, it was my expert, and when he said what he said, I was kind of proud of him, because there are individuals that, in my opinion, humble as it be, that have no risk whatsoever, but for the most part, LL recognizes there appears to be a consensus among experts that it's impossible to say that a person who has committed a sex offense, which by definition includes every person potentially subject to registration under the Act, poses no risk.
But wasn't your expert, didn't he say there are people who have really no risk, and that's not Doe?
Exactly, he did say that.
Okay.
Yes.
So he did say there is this category of people,
Yes.
zero risk.
Yes.
That's not what we're talking about here. We're talking about relatively low risk, right? But and so how do you get around that?
Well, because he didn't say low risk, he said relatively low risk.
But he also said not no risk.
And that's the whole crux of the problem, which is the difference between absolute no and low. In between there is where you get quotes like in 1211, the risk wasn't nil. Or you get issues like in my case, it's relatively low. That's where the problem comes in, and I don't know how you get past it other than to say, do we continue to defer to the expertise of the hearing examiner? I mean, at some point,
We're deferring to your expert.
yeah, but my expert, again, my expert said relatively, and Miriam says sort of. So if you say he sort of has a risk, is that enough? If that's enough, then I sit down and stop talking.
Oh, no, you can't sit down yet. I have another question.
Yeah, I knew that was coming.
Remedy.
Oh, yeah, of course.
Let me say, hypothetically, I agree with you. I don't see how we as an appeals court can give you relief from registration. I think the only remedy is remand.
They did it in 24341.
Yeah, that was the second floor, right? Or was that us?
What's that? That was you guys.
That's all
07,
right.
1940, 2009. No, I'm sorry. They did that in 523671, and that was decided in 19P 1638. And they say, let's see. The board decision not supported. We vacate judgment remand for an entry of judgment directing the board to relieve.
Direct to the board to relieve?
Yep.
And that's a Rule 23, right? Of course.
Again, please? I didn't hear you.
Yeah, that's a Rule 23.
Yeah. So, somebody back there agrees with me. I looked this morning to see.
We've agreed with you before.
I looked to see, maybe I get lucky in one of the, but no, not so much.
So, all right, stay with my hypothetical. It gets remanded to the board, then what happens? What does the board do?
Board is directed to relieve. But the conclusion says, because the board's decision was not supported by substantial, we vacate the judgment and remand the matter to the Superior Court for entry of a judgment directing the board to relieve Doe of any further obligation to register, remove his registration information from the registry, and notify the relevant police departments or departments.
And when is he up for his next reclass?
The decision was issued on 22 August, I think. Yeah, August 30th, 22.
Okay.
He's in Florida. He's in Florida, to the best of my knowledge, at this moment. Now, whether he still has an ongoing relationship with Jean Marie, and whether or not he has any ties that continue to exist in this state that would warrant, I don't know.
Okay.
Once they get, I've lived with this guy for 4 years. I took him from a 3 to where we are now. But I haven't talked to him since he called me and said I'm in Florida. I get to sit down?
Don't see any, It's your time, but I don't see
No,
any other questions.
let me just ask you this,
We do.
because I'm just pondering what you said, because I'm still not clear. When you say relatively low, can you tell me that again? What was your point there?
Well, I mean, the hearing examiner concludes that his risk is low. In order to have that decision, classification to stand up, it must be supported by substantial evidence. In the case of 523671, the whole conclusion the court made was, what's the evidence? My argument is, an expert saying his risk is relatively low does not equate with low. It doesn't mean the same thing. Relatively has meaning, or otherwise the word would not have been used. And therefore, it's less than what the hearing examiner adopted. So to sit back and say they accepted my hearing examiner's or my expert's opinion is an error, because they didn't say his risk was relatively low, they said it was low. So then you got to give me an objective, adequate reason as to why you didn't say relatively low and explain how that equates. And they didn't do that either.
Okay.
I may be talking semantics, but that's what we're all here for. Now can I sit down?
I don't see any other questions. We'll take the rest of your argument on your brief. Ms. Lomano.
Good morning.
Morning.
May it please the court, Gabrielle Lomano on behalf of the board. I think that the issues that Your Honor just brought up are really what's the crux of this case, and the most important thing to remember is the case law says that a hearing examiner doesn't have to agree with an expert's opinion. They just have to consider it. But this is a somewhat unique case, as Justice Blake pointed out, because typically the way this is presented is that the expert says low risk or no risk or whatever they say, and the hearing examiner concludes a higher risk. Here, what the hearing examiner concludes is exactly in line with what the expert said. Attorney Burkholder is pointing to this relatively low part, which is part of what the expert said. But I think what Justice Toone pointed out is really the most important thing here is to look at the language of what the expert said. He was asked on a question by counsel about, is there really such a thing as no risk? And he said, there are some offenders who present no risk, in his opinion, but this offender is not one of them. And there's no definition. Cognizable risk is a legal idea, right? A legal concept that we've come up with. I don't think it equates directly to the clinical field where a clinician will say no cognizable risk. But the way I view the expert's opinion and the expert's words on that point are, when he's saying there are people who pose no risk, he's talking about there are people that to him don't pose a cognizable risk. But this offender is not one of them. So I think it's really important to keep that in mind. And even if what Attorney Burkholder is saying is true, is that what the expert opinion is in terms of the risk is lower than what the hearing examiner ultimately concludes, that doesn't make it an error, because what the case law says is that the hearing examiner just has to consider it. They don't have to agree with it. And here, the hearing examiner gave very explicit details and findings about Dr. Soleil's testimony and all the things that Dr. Soleil considered, and the hearing examiner discussed all of those things and ultimately concludes at the end, I agree with his opinion that this offender is a low risk to reoffend.
What is the difference between relatively low and low?
I don't know. I mean, I think it's really the same. I think we're talking about semantics, but again, I think you have to also look at what he also says. He says relatively low, and that doesn't necessarily equate to the legal idea of cognizable risk, but I also think you have to look at what he says in terms of there are some people that in his opinion pose no risk, but this isn't that person. So he's not opining that this person poses no risk. He's opining.
So even though, and I understand why Mr. Burkholder is really drawing the distinction between relatively low and low, we can't truncate that from the remainder of the opinion, which is there are no risk, and this is not that case.
Right. Right. I think you have to look at the opinion as a whole. You can't just take two words, relatively low, out of his entire transcript of his testimony as well as his report. I think we have to look at it all in context as a whole. And again, that distinguishment of there are people that in his opinion pose no risk, this offender is not one of them. I think that's really the most important thing here. And ultimately, that's what the hearing examiner concludes. He concludes.
The hearing examiner could have, not necessarily on this record, but there are cases certainly where a hearing examiner could conclude that there was no risk and relieve someone of their obligation to register.
Right, if they conclude that they don't pose a cognizable risk of reoffense or degree of danger, because they have to have both, right? They can't find that someone poses no risk of reoffense, but they pose a low degree of danger. It has to be.
That doesn't require judicial oversight. The board can do that as part of its regulatory scheme.
Yes, and they do that. I've had cases where there's been a hearing, and at the end of the hearing, that's the decision that's issued, is that the person does not pose a cognizable either risk of reoffense and/or degree of danger, and then they are relieved.
Is that in the board's regulations, that option, or is that just sort of?
That's a good question. I don't know that it's in the board's regulations explicitly, because there is this whole history of case law that Attorney Burkholder was talking about in terms of DOE 24341 and DOE 8725.
The courts have essentially said you need to have this zero risk option, and so the board's kind of done that, but not necessarily incorporated into.
Right, because there was this idea that the law as it was framed was that if you have a lifetime obligation to register, the board can't relieve that. But then the courts came in and said, well, if you find that someone doesn't pose a cognizable risk, how can they be required to continue to register?
Okay.
So that's really where that idea comes from. And I think in DOE 24341, they give sort of a cumbersome definition of cognizable risk, but they talk about a perceptible risk that has to be able to be articulated and described based on affirmative evidence. So that takes us to the substantial evidence part here. I think that this, if you look at the case that Attorney Burkholder cited, the unpublished appeals court decision from 2021, in that case, the court said that there really was no evidence about anything that the hearing examiner could point to that showed that that offender was a risk to reoffend or degree of danger, that his offenses were very old. They had happened in 1993. He had sort of lived a model life since 1993 or since his release. He was at an advanced age, and he had physical ailments. And there really was no evidence in that case of his actual offending. There was just a conviction.
I skimmed that just now, and it didn't look, I didn't see reference to any expert in that case either.
No, so the issue in that case was the denial of a motion for funds.
Okay.
So there was no expert opinion, there was no actual police reports or information about the offense itself. There was just the conviction that he had been convicted of, I believe it was a statutory rape on one or two of his daughters. And then again, he had lived sort of this model life. That's not this case. In this case, and another important thing that the expert talks about is that this offender has a, what he calls, quote unquote, very concerning history. And he does have a concerning history. This is a person who committed 4 sexual assaults that the hearing examiner considered. There were 3 additional sexual assaults that were reported that the hearing examiner said, I don't have enough information to rely on these. But he committed 4 very violent sexual assaults of either extrafamilial victims he had just met or stranger women. The assault involved a very high level of violence. He was heavily using drugs or alcohol at the time. He served long sentences. Some of these, other than the first offense, all of the offenses were committed after he was already on parole for the prior sex offenses. He then goes on to serve his sentence and be civilly committed as a sexually violent person in California, our equivalent of an SDP, for a long period of time. So this is a person who has a very concerning history. There's real affirmative evidence that the hearing examiner considered and relied on in terms of applying the relevant risk factors, including risk mitigating, but high risk and risk elevating factors. And so this is a very different case than DOE 523671, where there really was no evidence other than just the fact that he had been convicted of a sex offense. In this case, we have very, very affirmative and articulate evidence about all of the high risk and risk elevating factors that apply to show that, in line with what the expert opines, this offender does still pose a risk. It's low, but he still poses a risk. And if there are no further questions, I'll rest on my brief.
I don't see any. Thank you both very much. The case is under advisement. Nice to see you both.
Thank you.
Our next case is Maureen Mirtilli LLC versus Idlewild Acres LLC and another. Docket number 24P321. I'm sorry if I've mispronounced any of that. Good morning. Mr. Henshaw, when you're ready.
Yes, Your Honor, thank you.
Thank you, Your Honor. Good morning.
Morning.
Madam Chief Justice, Justice Hodgens, Justice Toone. My name is William Henchy. I represent MAUREEN'S MIRTILLI, LLC, which is the appellant in this case. My client appeals from a summary judgment by the land court determining on a declaratory relief count that my client's property does not have the benefit of an easement to access the 3 cranberry bogs that it owns in East Sandwich over registered land owned by IDLEWILD, which is the appellee in this case.
And just to be crystal clear, because I need the ground rules, are you only going forward on so much of the claim about the prescriptive easement over the non-registered land? Because your brief, I mean, you talk about the express easement and the registered property. I just want to make sure I understand what's before us.
There are a couple of adverse possession prescriptive claims in the case, Your Honor. One is hotly contested by IDLEWILD, and that rests on an affidavit of Peters Hanlon, who was the prior owner of my client's property, indicating that he accessed the property before his purchase from North Shore Boulevard in Sandwich. There is an argument that that issue was not properly before the court because it wasn't raised in the pleadings below. My position on that, Your Honor, is that that one boils down to one of two outcomes. It's very simple. Either it's in the case, in which case there is clearly a question of fact which precluded summary judgment, or if you agree with the appellees, it's not in the case at all, one way or the other.
But I think my question is, because what I understand is that on summary judgment, Judge Spicer did 2 things. He rejected your claim that you have an express easement over the registered property.
Yes.
And that to the extent that there's a claim of an easement by prescription over the non-registered, he also rejected that. When I look at your brief, I want to be clear that we're deciding, I believe, just the prescriptive easement question. Or do you think it's all in front of us?
Oh, no, I think it's all in front of you, Your Honor.
Okay.
No, Your Honor. We are appealing from the court's determination that we do not have an easement over the registered parcel.
Okay.
What were you going to say about your alternative position, if we assume that the appellees are correct, that this issue wasn't pled?
I can barely hear you, Your Honor.
What were you going to say about if we agree with the appellees that the issue about the boulevard easement wasn't pled? You were going to say something else. In that case...
It seems to me it comes down one of 2 ways. If the court agrees that that is in the case,
yes, okay,
then we clearly had a question of fact and summary judgment was precluded.
Okay, and if it's not in the case, you're going to say...
It's not in the case. And in that case, we may have another action in the land court, but if it's not in this case, the appellees are correct. I don't concede that, Your Honor, but if it's not in this case, it's not in this case.
You kind of affirmatively pled in this complaint that easement wasn't available to you, right? That was kind of strengthening your case for the other arguments, right? So it's almost like you averred in this case that you didn't have access through this.
That's right, Your Honor. That's
okay.
That's the heart of the argument on that issue.
Right.
And I didn't plan on spending a lot of time on that here.
Good. That's fine.
But that's fine, Judge. I appreciate the opportunity to clarify my position. But Justice Blake, in answer to your question, I don't know if the court has the briefs, but at page 15 of my brief and attached to the court's decision, there is a so-called reference sketch that Judge Spicer used and the parties used to help orient the court.
Did you say page 15?
1-5 of our brief.
Yep, I'm there. I see it.
See the diagram, Your Honor?
And I appreciate that it's in color so we can understand the key.
And there is also a prescriptive claim across the, it's in green, Your Honor. There's also a prescriptive claim in green that crosses IDLEWILD unregistered 2. And we believe the land court erred in determining that we had no such claim. I can briefly tell you what that's all about, Your Honor. What the land court determined is that we could not assert a claim for the benefit of Hanlon 3 over that parcel because of the bright line test that would constitute an overburdening of an easement. We did not claim an express grant over the unregistered portion. We claimed prescriptive use of that portion of the unregistered land. And the court just, we suggest in our brief, Your Honor, misapplied the standard there. Is that clear, Your Honor? And I apologize, there's a lot of moving parts in this case, and I do want the court to understand
I
what.
do. Thank you.
Okay.
I mean, the court said that the prescriptive easement over parcel 2, that's what we're talking about here, right?
Yes, Your Honor.
It would dead end at the registered land portion
Yes.
of the property, right? So
Yes.
therefore, there's really nothing to consider.
But that isn't quite what the court said. I do think that was implicit.
The second point was the overloading issue, right? But it seems like there's two different problems with
I agree with that, Your Honor.
Okay.
I agree, and I claim error as to the overloading. I agree that if we don't have a right to cross the registered parcel, that prescriptive claim is in essence moot, if that makes sense.
Okay.
How am I doing? Am I answering?
Go
Okay.
ahead, yes, yeah, that's helpful, thank you.
So I want to get to the more difficult claims in the case, which are the issues surrounding the application of Jackson v. Knott and its progeny to the facts of this case. And the facts of this case are a little bit unique, and it is a bit of a square peg in a round hole. What happened here was at the time of prior to the registration, my client's predecessor and the registered land's predecessor owned in common parcel R4, which is Hanlon 3. At the time of the registration, Emma A.G. Foster owned 2 parcels of land not adjacent to. Emma A.G. Foster owned a parcel of land identified as Emma A.G. Foster et al. On the registration plan. And Emma A.G. Foster also owned Hanlon 3 in common with her husband at the time. The petition for registration stated in it, signed by John Wing, the owner of the registered land, stated in it, there shall be appurtenant to the land of Emma A.G. Foster et al., a right-of-way over the middle way going across the registered property. I'm paraphrasing slightly, but that's very close. And that language is highly relevant to the outcome of this case, because what the land court decided was that as a matter of law, the language, the land of Emma A.G. Foster, could only apply to the parcel identified by Emma A.G. Foster shown on the registration plan. But the language in the registration petition did not say the land of Emma A.G. Foster as shown on the plan. So there's an ambiguity in the language used by the grantor here as to what land he was granting or reserving, however you want to look at it in the petition registration, over what parcels of land owned by Emma A.G. Foster were being given the right to cross his land in the registration case. What then happened is Emma A.G. Foster was given notice of the registration case and filed no objection. And we suggest the absence of an objection gives rise to an inference that she understood and that the granting party understood that Emma A.G. Foster was to have a right in the registered parcel to use this right-of-way.
You know, I have to say, both parties have made terrific arguments, and I enjoyed reading the briefs quite a bit. And I agree with the judge below when he said, upon reading each argument, he said, yeah, I agree with that. You know, that seems right. And it kind of went back and forth. But the problem I'm having with your argument now is it seems to do violence to the registration statutes because the purpose of the statute is certainty and so forth, and to eliminate doubt. And you seem to be trying to steer us the other way, that we should be embracing this doubt and seeing something's behind it, because the statute is pretty clear that holders of a certificate of title take free from all encumbrances except those noted on the certificate, and they're not noted on the certificate. And in fact, as you indicated, that R4 parcel, the Hanlon 3 parcel, is not on the map at all. So it would seem that if we were to give life to the statute as we're required to, that seems to foreclose your argument, doesn't it?
No, Your Honor, I don't agree.
And why not?
Let me tell you why. Because the cases interpreting that statute go much further than that. So my first response is that on the face of the registration certificate, not the petition now, but the certificate of registration, there is language that states that the ways shown on the plan, which is incorporated into the certificate, are subject to the rights of all persons legally entitled thereto. Now, the appellees have argued, based upon a number of land court cases that say that language, without more, is not sufficiently particular to conform to the statute's requirements that the court just indicated. However, Your Honor, this is not one of those cases where we are talking about language like that without more. We have the express grant of an easement, and I suggest to the court that's what it is. The express grant of an easement in favor of Emma A.G. Foster in the petition itself. It's an instrument signed by the grantor. It identifies the parcels to be benefited, land of Emma A.G. Foster. It identifies the location of the easement, and it identifies the use to which the easement should be put, access over the registered parcel. Secondly, Your Honor, if the court disagrees with the notion, I'm running out of time, if the court disagrees with the notion that the language in the certificate is not sufficiently particular, the court takes that position, Jackson v. Knott and its progeny lay out two exceptions to the requirement that every easement be listed on the face of the certificate. And we believe both of those exceptions apply to this case, Your Honor. The first Jackson v. Knott exception, and I want to be sure I get them right, is where on the face of the certificate, excuse me, Your Honor, I had this, this reminds me of my moot court in law school. I can still recite the standards of that today, but I forgot it in the moment. When there are facts described in the certificate of title, which would cause a reasonable person to make further investigation into documents within the land registration system to understand whether or not the land was subject to an easement. One of those facts is the language we just discussed. The other is the plan, and those matters are closely established in the cases, Your Honor. That's settled law. What is unsettled, and what is at issue in part in this case, is whether or not the registration petition itself is a document within the land registration system to which a purchaser should look. The cases seem to go both ways on that, Your Honor. Jackson v. Knott suggests no, but in a citation to, of course I had it again, Butler versus Haley Greystone, Jackson v. Knott refers to a case where the Supreme Judicial Court did in fact look to the petition to determine whether or not the petition elucidated whether or not the land was subject to an easement. The second Jackson, did I lose you, Your Honor? I'm sorry.
Oh, no, no, go, keep going.
The second Jackson v. Knott exception deals with when the owner is on notice of an actual notice of an easement burdening his land. And here we have several facts which give rise to that actual notice. The first is that the deed to Idlewild 2, Idlewild's unregistered parcel, contains within it an express easement, and this is briefed and set out in the briefs, Your Honor, an express easement across the registered parcel out to Ruth's Road. And I want to point out, if you look at the reference sketch, and if you look at the photograph that is contained at page 14 of my brief, the aerial, which is also in the record, Your Honor, you will see that Idlewild 2 is just to the west of Hanlon 3. It shares in common as a boundary the right-of-way, and it is a way that the appellant seeks to call it, the appellee seeks to call it a farm road, but these are all referred to in the instruments as ways and roads. It shares in common with a way which is the boundary of the two parcels, and that way extends out across the registered land to Ruth's Road. It's the disputed way. So when Idlewild purchased its property, it was on explicit notice that there was an unregistered way, an unregistered easement burdening its land. And in that case, the second Jackson v. Knott exception is very clear that you look to both registered and unregistered documents. So if the court takes the position that the petition is not a document within the registration system, under the second Jackson v. Knott exception, that petition goes right to it. Your Honor, I'm down to 13 seconds, so I'm going to have to wrap up. I thank you for your questions, and I will rest on the briefs.
Thank you so much. Attorney Goodhart.
Thank you, Your Honor. May it please the court, Lisa Goodhart. With me is Alessandra Wingirter. Let me start by tackling the question you asked at the outset.
What's before us?
What's before you, Your Honor? And I think I have a graphic that will help clarify things for you. It is in the record at page 277 of the record appendix, and it is actually a different version of the sketch plan that Mr. Henshey showed you, but this one has been annotated in a particular way. So this is what I want to explain. If you go to A277, you'll see the red line that basically runs from the west, from Roos Road, over to the Mirtilli parcels. And for that, Mirtilli's claim was in part, we have an express easement over registered land. That's the Idlewild 1 parcel, and I'll get to that. And then as to the unregistered Idlewild 2 parcel, we have a prescriptive easement. My brother has conceded that that's basically moot if we agree that you cannot get, and it's not a matter of agreeing, it's clear law, you cannot get prescriptive easement over registered land. So therefore, that prescriptive claim dropped out of the case. It's all about Jackson v. Knott as to the disputed way. What's before you on appeal is an argument that isn't rooted in a claim that was presented to the court below. And that is this blue dotted line you can see on A277 that does not run to Roos Road, which the complaint makes clear is what the dispute was all about, the disputed way to Roos Road. This alternative unpled easement is a dotted blue line that runs from the upper corner of R4 all the way up towards North Shore Boulevard and North Shore Boulevard Extension. And I'd like to tell you briefly, before I go on to Jackson v. Knott, where are the record references that definitively compel the conclusion that this is not in the case? And there are several. Okay. The first is the first paragraph of the introduction of the complaint, which says, access to plaintiff's farm is from Spring Hill Road in Sandwich down a private way called Roos Road and across the land of Idlewood. Number 2, paragraph 5 of the complaint, and I should point out that this is a verified complaint, so it functions as an affidavit. Plaintiffs have an easement by grant to cross Roos Road in Sandwich from Spring Hill Road to their cranberry bogs across land owned by Idlewood. Number 3, paragraph 29 of the complaint again refers to an easement that runs across from Roos Road. Beyond the verified complaint, we have 2 interrogatory answers, again, statements under oath by the plaintiff, and I would refer you to interrogatory 10, the answer to interrogatory 10, and the answer to interrogatory 17. They appear in the record appendix at pages 182 and 184 and 85. And in those interrogatory answers, Mirtilli says, the only way I have is Roos Road. And if you don't give me Roos Road, the disputed way to Roos Road, I'm landlocked. So it's an affirmative disclaimer of this dotted blue line easement that goes up to North Shore Boulevard. Now, having said under oath, the easement from Roos Road on the west to the east is the only access I have.
And that's the red line.
And that's the red line.
Okay.
You can't come in now and make it an issue here.
Not in this case, probably, but can they bring a new action to sort of try to establish an easement to North Shore Boulevard? Maybe we don't have to decide that. I'm just curious, if we take your position as unpleaded, is there anything barring? I understand that they may be in trouble because of these statements they made in this litigation, but is there anything that prevents them from filing a new action?
It's the rule that requires that all claims arising out of the same transaction and occurrence and operative facts have to be brought in the same action. You cannot split the case. And I do want to point out to the court that
entirely different easements. Does that one easement to one road, one easement to another road? Are those considered the same kind of operative?
Well, when you're suing Idlewild, okay, and Idlewild owns the land over both easements, then any easement you have against Idlewild, you have to bring. And they did not bring that claim. And I would remind the court also that this action began in Barnstable Superior Court with a broad-ranging complaint, including civil rights and trespass and nuisance and everything under the sun. The one piece that was carved off and came to the land court was this count 1, which had to do with the claimed easement over the disputed way. So there was no amendment of the pleading. It certainly wasn't tried by consent. In my brother's brief, he relies on some stray comments that the trial court judge made during colloquy at the oral argument. And I would suggest that to the extent they suggest the court thought this issue was in the case, it's clear from the final decision. And that's what's we have to rely on, and that's what's appealable, not colloquy, that the judge clearly concluded it was not in the case, and I would refer you to footnote 18 of the decision. So the blue way is not in the case. Now we come to Jackson v. Knowledge.
Yeah, let me ask you about that. Let me ask you about the decree, because what do we make of that language in the 1931 decree where it says, so much of said land as is included within the limits of the ways located approximately as shown on said plan is subject to the rights of all persons lawfully entitled thereto in and over the same.
Yes.
So
let me tackle that,
okay.
Your Honor. And of course, you get there because you start by looking to the text of the decree itself. And I just want to flag the fact that there is nothing in the text of the decree that refers to any of the Mirtilli parcels. But there is this language that you referred to. So much of said land as is included with the limits of the ways located approximately as shown on said plan. So that's what we're limited to. This description does not meet the standard for specificity of an easement. It doesn't tell you which specific land or any of the qualifying factors, but it does tell you that whatever easement we're talking about, it is limited to what is shown on said plan. So under the first Jackson v. Knott exception, the reader of this certificate can't just say, well, that's not specific and it doesn't mention Mirtilli or his predecessors, so I'm done. Under the first exception to Jackson v. Knott, there is an obligation to look not just at the certificate, but if the certificate points you to something else, you have to go to that. If the certificate pointed to another certificate of title, you'd be expected to read that. Here, the certificate points you to the plan. So you go to the plan, and that is Plan 14469A, and that is, sure it's in the record appendix, but it's in the addendum to my brief at 91. That is the 1931 plan. And so what you know from looking at the certificate of title is whatever easement right anybody holds, it is appurtenant to property shown on this plan. And what is shown on this plan is land of Emma Foster. That is an unregistered bit that Idlewild also now owns. But if Emma Foster had rights, I think it's fair to say that you would consider at most Emma Foster's parcel, and there is a right-of-way shown that goes just to the south of her parcel, the Foster parcel, now owned by Idlewild, and as you will see, it dead ends in the middle of the page, eastern corner, at the land of James Friedman, which is now Idlewild too. You never get over to Mirtilli. And the fact that Emma Foster may have owned other parcels of land not shown on this map, elsewhere in Barnstable, elsewhere on Cape Cod, elsewhere in New England, is frankly irrelevant. The record shows she owned 9 different parcels, but under our registered land system, you only look at what's on the certificate and what's on the plan.
Is there a case that says you can't look at the petition for registration?
Yes. Jackson v. Knott itself.
Well, Jackson's, you cite that, you say if a plan is referred to in the certificate of title, the purchaser would be expected to review that plan. Does it affirmatively say you don't look at the petition for
It
registration?
does, and I'll give you the language,
Okay.
if I may. The purchaser need not look beyond the decree, for all facts prior to the decree, including the petition for registration itself, are irrelevant. And that's Jackson v. Knott at page 113 of the Massachusetts Reporter, 418 Massachusetts, citing Butler versus Haley Greystone. I can't help but note that we are arguing with the smiling face of the author of Jackson v. Knott, Justice Graney, looking down on us. So I think Jackson v. Knott is explicit.
Okay.
You don't look at the petition. And I think the land court's explication of why that's so in the decision is worth reviewing. It holds up well, and he's correct as a matter of law. So I think what I should do in whatever time
Actually, wait one second.
Yes.
Let me just ask you about the plaintiff's argument about Idlewild 2, the parcel R2, which goes to the second exception under Jackson v. Knott. Why isn't that actual knowledge of the easement?
I'm glad you asked that question. Jackson v. Knott, and again, the context is because the whole value of the registered land system is to give you one place to look, and you don't have to go through rabbit holes to hunt title and maybe miss something. A land court has decided these are the only encumbrances that go with this land. So Jackson v. Knott basically said, we are going to inject two very specific, very narrow exceptions to that hard, bright line rule. And they're really anti-fraud exceptions. And one is, you can't close your eyes to something that's on the face of the certificate or on the face of the plan and makes very clear that there's something there. You can't close your eyes. And the second exception is, you can't, with actual notice, and Jackson v. Knott says what we mean when we talk about actual notice is not notice of past use or present use or somebody said this or that. It is actual knowledge of the instrument that creates the easement. There is no such easement. Even if one went looking for it, one would not find it. So you have to look at the very tight, narrow definition of actual notice as the SJC has declared it, and there's not a shred of evidence that my client had actual notice of any such instrument. Indeed, he couldn't have. There is no such instrument. And the only rejoinder I hear to that is, well, look to the petition that operates as a grant of easement. Again, it does not as a matter of law, and I think the land court's decision makes that very clear.
And is that why this case is different than Duddy?
Oh, Duddy, now you're testing me, Your Honor. I apologize.
So in Duddy, the registration plan showed a road that was going to be subdivided in the future. So there was at least, people were on notice.
Yes.
And does it need to be that distinguishable, that clear?
It needs to be that clear. That's the point of saying, if we require you to look past the text of the registration certificate, the only thing you have to look to is what's in the registration system that you would be pointed to, another certificate or the referenced plan.
Okay.
Can I just ask, assuming everything, your position is correct across the board, what is left for the MIRTILLIs to do? What use are cranberry bogs that don't have access to a public way? What can they do?
Well, that's an understandable, equitable concern, Your Honor. I would start by pointing out that MIRTILLI purchased this land with this case pending. Okay, so they knew
they're getting into, okay.
And I assume they got a bargain because they bought it with a sharply disputed claim that there was no easement at all. And what I would say is the notion of an easement by necessity or the fact that the common law really doesn't favor landlocked properties, that only goes so far. And when that runs into the strict rules of our registered land system, it is the rule of our statute and Jackson v. Knott that trumps. And so I would respectfully say, Your Honor, you're not to worry about that.
Okay.
I think we're going to have to leave it there. I know both of you have done a tremendous job in your briefs and your arguments. This is a very sad and difficult case, and we very much appreciate the presentations today. So thank you very much. The case is now under advisement.
Thank you, Your Honor.
Thank you.
Our last case on today's list is Joseph T. Baker versus the Massachusetts State Police Department, docket number 24P112. And before we start the timer, Mr. Baker, I know that you are representing yourself and you've had the benefit of seeing some of the arguments here today, so it's not unusual for us to interrupt you with questions. We will have you stand at the podium. You'll see the lights, and I know the court officers have explained this to you. Just if you go over, I will let you know that you've gone over. When you're done, opposing counsel will then present his case. You stay here for that, but then you don't get the opportunity to speak to us again. We take the matter under advisement, and you will get a written decision. I was going to say in the mail, but that's old school. I think it's now by email. So I just wanted to make sure you understood our process. Okay, so when you're ready, you can go right to the podium, and we're happy to hear your case.
Okay. Good afternoon, Your Honors. If it would please the court, my name is Joseph T. Baker, and I'm a retired lieutenant from the Massachusetts State Police, having served just under 26 years of honorable service. I was a road trooper, worked my up to be a sergeant for 4 years, and then a lieutenant for the last 2.5. As you stated, Chief Justice, I'm not an attorney, and I'm representing myself here today pro se, and so I beg the court's forgiveness and understanding if at some point I don't use the correct legal terms, but I feel I have a pretty good understanding of the proceedings. I have a prepared statement. If the court would indulge me, I'd like to try to get through. Your Honors, I'm told that I've what's left of 15 minutes to try to explain to you how a 26-year stellar career came to a very abrupt and miserable end, and I will endeavor to be articulate and concise to that regard. Justices, the crux of my argument before you today is to illustrate that my career ended prematurely because of very harsh and untenable circumstances with which I was presented. The legal term for this is constructive discharge. Now, as I stated previously, I willingly concede that I'm not an attorney, but I've researched and delved extensively into what constitutes a constructive discharge. I've come to understand that the threshold to prove such a case is onerous and must be presented on the basis of legal precedents, not simply emotions or philosophical perspectives. Now, every legal scholarly definition of a constructive discharge seems to have commonality in the tenets that an employer made the conditions of employment so untenable to the employee that he or she chose to resign. I think it's interesting and significant to note that several legal scholars have chosen to characterize it as constructive dismissal or constructive termination. In layman's terms, the employer imposes such adverse conditions knowing full well the employee will likely leave rather than endure. What I intend to show you today is both a gross and derelict violation of due process due to the outcome I was faced with. Now, just to recap, again, if you'll indulge me, this is important to make you understand. I was a duty lieutenant at the regional troop headquarters in Middleborough, basically a shift commander overseeing the various barracks throughout southeastern Mass, Cape Cod, and the islands. This is often a stressful and laborious assignment. A duty officer cannot leave his post. The duty offices throughout the 6 troop headquarters of the state are staffed 24/7, and a duty lieutenant is essentially tied to the telephone and radio throughout their entire shift. An emergency may come up at any particular barracks, and immediately the duty officer is the one responsible. As a married father of 3, I want to point out to you that throughout my entire 26 years in the state police, I was never afforded a Monday through Friday position. Still working nights, weekends, and holidays, despite having tried and been passed over numerous times. twice by lieutenants who had been court-martialed by the state police. My supervisor, Major Thomas Majensky, the same guy who passed me over repeatedly for more favorable positions within the troop, treated me in the most despicable and demeaning manner in the course of the 2.5 years I was there. Ironically, as a commissioned officer, we're not part of a union. We're actually out of the union. A lot of people don't know that. Troopers and sergeants are in a union, but when you become a lieutenant, you're lower management. Therefore, I had really no means of redress for grievances, if you will. Major Majensky openly mocked me in the presence of others and even subordinates, and always felt that he was untouchable. All the while, I was documenting the various instances of abuse, and this all culminated in January of 2019. One morning, I inadvertently stumbled upon him having a conversation down the hall, a public conversation standing outside the captain's office with an audience of several ranking officers, as well as one subordinate. The major was openly mocking, among other things, my deep voice, my use of vocabulary that was apparently beyond his education, my report writing skills, and eventually mocking the fact that I was in church that prior weekend when he repeatedly texted me and then tried to call me about a recent investigation I had conducted for him. I personally stood there and watched and listened as he paraphrased and poked fun at the disparaging text messages that he had sent me on that Sunday, all to the sound of laughter from his audience in the captain's office, showing the text messages to them and how he disparaged me while I was in church, making fun of the fact I was in church with my family. Put yourself in my shoes for 1 minute and imagine what that felt like. Now, as a result, I confronted him and it didn't go well. I had had enough at that point. I reached out to a lieutenant colonel at General Headquarters in Framingham and I took him up on a number of charges, not the least of which was conduct unbecoming. Immediately, the department attempted to coerce me into a mediation agreement, but I showed them 2.5 years of what had transpired, and I insisted his conduct warranted investigation and adjudication. Now, Your Honors, that was the background, but this is where it gets dirty. Initially believing the department was going to conduct an honest and fair investigation, the major was restricted from the troop headquarters whenever I was working, a sort of verbal restraining order, if you will. I contacted an attorney and began obtaining legal advice. A captain from the harassment investigation unit was assigned the case, gave me a form, and asked me to check a box where I thought the criteria of harassment was established. He told me if I couldn't check one of these boxes, i.e. race, religion, creed, age, sexual orientation, then I didn't have a case. I felt backed into a corner and I chose religion only because I felt if I didn't check one, they'd reject my complaints. But, right off the bat, something dawned on me. The lieutenant colonel overseeing the harassment investigation unit, Lieutenant Colonel Richard Warmington, was a personal friend, mentor, and direct supervisor to the accused abuser, in this case, Major Majensky. Clearly, this was an obvious and flagrant conflict of interest. At the behest of my attorney, I requested in writing that Lieutenant Colonel Warmington recuse himself from the matter entirely and received an email back from the investigating officer the next day saying Lieutenant Colonel Warmington had agreed to recuse himself from the investigation as well as a review of the final report. As you will hear, that didn't happen. Now, during the course of their so-called investigation, several witnesses, including the accused, were interviewed. As you know, Justices, in any court, the prosecution is allowed to present witnesses, and then the defense is afforded cross-examination. That process doesn't exist in the state police, not in their system. At no time was I or my attorney allowed to be present during the witness interviews. The investigating officer and one other independent commissioned officer were present for these interviews, nor did they ever allow any of the corroborating witnesses that I provided names for who could support prior allegations of misconduct. They were never interviewed. Approximately 6 weeks later, I was handed a letter advising me that all 4 charges against the major had been dropped. The investigating officer conveniently classified 2 of the charges as unfounded and the other 2 as not sustained. Even the conduct unbecoming was dismissed, and it stated Major Majensky was therefore exonerated. But guess who signed the order? Yes, Lieutenant Colonel Richard Warmington, the same guy who stated he would, in writing, which I have, that he would recuse himself. If this isn't the bold-faced definition of a cover-up, I don't know what is. Now, Your Honors, I've been in law enforcement for just over 37 years now, and I've testified at numerous district courts, superior court, and even a few civil cases. And whenever I saw a judge be recused from a case, and I've seen a few for various reasons, certainly that judge does not sign the final decision for obvious reasons. But I suggest to you that the state police didn't care. They operate on their own judicial process, and to say that it's arbitrary and capricious is an understatement. Now, I ask you what a reasonable person would do upon hearing such unfavorable news. I asked what my right of appeal was. I was told by none other than Lieutenant Colonel Wilmington through channels that there was no avenue of appeal, and that if I wanted to pursue the matter further, I would have to take it on my own to MCAD, Mass Commission Against Discrimination, or the courts at my own expense. One guy gets to decide the outcome of a potentially career-ending case, and there is no established internal mechanism for appeal. Now, as to the witnesses and what they had to say, I did next what any reasonable person would do who was not permitted to be present during their interviews. I requested their transcripts, Chief Justice. Your Honors, both my attorney and I were told we were not privy to their answers, not even the questions that were posed. Talk about a violation of due process. I'm not an attorney, but I know due process. I've been in this business for 37 years. I suspect a first-year law student would stand up and protest, saying, how can I possibly build a case if I can't see what the witnesses said and not even the questions that were asked? This is preposterous. Talk about an egregious violation of the rules of discovery. But again, these are the so-called guidelines by which the internal state police judicial system operates. Now, if I ask you, Justices, what if some of what the witnesses answered possibly or potentially corroborates the information in my complaint, and my attorney had been able to see that? That would have clearly undermined the state police's effort to cover this up, and you and I both know that's called withholding exculpatory evidence, and it certainly would not be allowed in any legitimate court of law. Justice Toone, if I may, last week you heard the matter of Adams versus the Mass State Police. You posed a question of Attorney Moynihan about the alternative options presented to a defendant in the event of an outcome of a duty status hearing was not in his or her favor. Attorney Moynihan apprised you there really were no options, and that the process was rather arbitrary and capricious, and that the Colonel retained a great deal of authority over these matters. Well, respectfully, Your Honors, I suggest if you were to look at the entirety of the state police adjudication system, you'd see the entire system is arbitrary and capricious. That's coming from a guy who was never in trouble and had a stellar career. I saw it countless times. The fact of the matter is, the state police judicial system, I'm sorry to say, but I'm being honest, is not geared towards justice. It's geared towards protecting the department and preventing outside embarrassment, whether you are a defendant who's in trouble in a trial board or someone like me who's a plaintiff against them. Hence, why so many of these cases end up before civil service or the courts, as you've surely seen. So now the state police tell me that as a certain date, the major's coming back and I have a few choices. I can go back to work for the same abuser, or, ready for this, they will transfer me. Now, shortly, my brother counsel will tell you in so many words, oh, we didn't force him to leave. He was given options, and he chose to leave on his own accord. What they don't tell you is what those, quote, other options entailed. Going back to work in the same hostile work environment I had endured for the past 2.5 years, knowing full well I'd never get a job, or a more favorable job, or a Monday through Friday position, or be transferred an hour and a half from my home one way. Do the math. That's 3 extra hours of commute time. Wait a minute, I thought I was the victim here. Option 3 was even worse. Be transferred to Troop C in Holden for an hour and 45 commute one way, because we're not allowed to commute through Rhode Island in our cruises. Isn't that a wonderful way to treat a 26-year veteran lieutenant with a wife and children?
So I want to pause you for a second, because we have to connect this to the law. Are those two options, the two commute situations, would you describe those as a change to your work conditions?
Absolutely, because I was 20 minutes from where I was presently stationed. And if we encounter something on the way in a marked cruiser, we have to stop. An accident, a disabled vehicle. So
Justice Toone has a question.
Yeah, we probably should ask some questions now. Did you ask for any other transfer other than those 2 that you were offered?
There is nowhere else I can go, because as a lieutenant, I couldn't go as my dad once again. Why don't they just put you in a local barracks? The highest ranking officer in a barracks is a lieutenant, and being a lieutenant, I couldn't go there unless I was a station commander, which is a position I was looking for all those years, because it's Monday through Friday.
It was already
weekends,
lieutenant there.
It was already a lieutenant there.
Yeah. We understand your allegations, and we actually have to credit them at this stage of the proceeding, because that's the standard. So I just want to try to ask some questions about the legal claims that you have.
Okay.
Oh, if you want to finish quickly, that's good, but we do want to get...
So my point is, it would have taken even more time away from my family to endure, either the options were go back and endure the abuse and keep your mouth shut, or we'll transfer you. Remember the tenets of constructive discharge I presented? In all my years in law enforcement, Your Honors, I have never, ever seen the victim in any abuse or harassment case be the one that's asked to leave. And I've seen a lot of them. So how do they get around that? They have to take away the title of victim. And in order to do that, you have to first remove the title of abuser. In this case, they did just that. But who did it? Lieutenant Colonel Warmington, his friend and mentor. Lieutenant Colonel Warmington exonerates Majensky and therefore opens the door for him to stay, and now we can justify transferring Lieutenant Baker, the complainant. It's ugly, it's pathetic, it's disgusting. But look at the files in front of you. His signature is right there. Remember when I said to prove constructive discharge, you must base it on the legal precepts? The evidence is right there in front of you, Justices. It's irrefutable. Lieutenant Colonel Warmington's participation in the pre-planned outcome of the investigation is obvious. His signature on the final decision unequivocally proves it. I'm actually somewhat surprised that they were that obnoxious and bold about it, quite frankly. Basically, the state police said in layman's terms, go back to work for him, shut your mouth, deal with it, because you're not in a union, or we'll transfer you somewhere far away. See how you like that. Clearly, this meets the threshold of a constructive discharge. To recap, we have a flagrant violation of due process, evidenced by an obvious internal cover-up. A colonel who was supposed to recuse himself became the judge and signed the order. We have a potentially exculpatory evidence being withheld by the primary investigator. Can you imagine not being able to see the witness statements? And we have a glaringly obvious violation of the rules of discovery, where the victim and his counsel were denied, that being me, access to the transcripts, not even access to the questions that were, how do I know if, as a first-year law student, I'd say, how can I know if the actual questions were the correct? I couldn't even see the questions. They redacted all of it and said you're not entitled to it. That's not jurisprudence. Incidentally, I went to MCAD when I first left the department. I was assigned a 23-year-old investigator who told me that because that I was not a minority, and because the major was not a minority, I didn't have a discrimination case.
Mr. Baker, we may have to leave it there. I just want to see if the panel has questions.
Can I just ask quickly? So,
certainly.
On the constructive, the two claims that you've appealed are retaliation and what you call constructive discharge.
Yes, Your Honor.
Now, constructive discharge isn't actually a claim in itself. It's an element of a claim. Now, it could provide the basis for your retaliation claim, and we're going to ask the State Police's counsel about that next. But there also is a different claim called wrongful discharge. I want to know if you are essentially asserting that claim, because in your brief you mention having investigated another commissioned officer for an accident involving a pedestrian and having received adverse but you don't actually plead that. So is that the basis of what you're arguing now, or is that a separate issue from?
The investigation that I conducted for him was about a pedestrian. That was the one he was making fun of that day because of the vocabulary used in that report. That was disgusting what he had to say about it, and I heard all of that. I watched him say it. But to answer your question, Judge, respectfully, I'm not claiming. What I said was, several legal scholars have said, if you look at the tenets of constructive discharge, they set it up. They orchestrate it, knowing you'll leave, so the term can sometimes be considered constructive termination. I don't claim that I was terminated, but I ask you to consider this. A 26-year tenured employee who was 8 spots away from being captain. What does that mean? That's a 15% increase in pay and my pension. I called on a Thursday and retired on a Friday after 26 years. Does that sound like ordinary discharge to you? I submit to you it meets the...
You're well over your time. Justice Hodgens has a question for you.
I just wanted to let you know that we've read through the record, and as Justice Toone had mentioned, that we accept the allegations as true, okay? And I can't speak for the panel, and I don't know where we're going with the case, but I can assure you of this too, that from what I've read here, your family should be very proud of you for your 26 years of service, as you should as well, and for your presentation here today. I'm sure it's very difficult. It's hard enough for lawyers, but when someone feels they've been wronged, and to pursue it this far and to address the court as you've done, It's just very well done. I
Thank
appreciate
you,
it.
Judge. Thank you, sincerely.
Thank you very much. We're going to
Thank you,
have to
Chief
leave
Justice.
your
Thank you,
part
Judge.
here. Please don't leave. You have a seat here while we hear from Attorney Farrell.
Good morning, Chief Justice Blake, Justice Toone, Justice Hodgens. My name is Sean Farrell. I represent the Department of State Police in this case, and may it please the court. State Police here is asking that the Superior Court decision to dismiss the Lieutenant Baker's complaint be affirmed. The complaint, is under the Rule 12 standard, taken as true, simply does not get over the 12B6 hurdle in this case.
I really have trouble with that. So if we were here on summary judgment, we would be having a completely different conversation. But when you look at what 12B6 talks about and what Iaquino tells us we're supposed to do, it does not take much to get over the rail.
I understand that, Your Honor, and I agree, but I believe in this particular case, it simply doesn't get over that hurdle.
I'm really struck by the option to stay at the barracks with the individual at issue. That is what it is. But the two offers to you can go to these two barracks, but here's how your life is going to change in terms of your day, adding 2 to 4 hours more. Why is that not a change in work condition?
Well, a longer commute, Your Honor, without more, as indicated in this complaint, without more simply does not add to an adverse employment action or a material adverse employment action. There's no indication, absent from the complaint, is any indication that there was wear and tear on the car, perhaps, or that there was extra gas mileage.
What about wear and tear on the human being?
Well, Your Honor, I would suggest that this is a common...
Reasonable inference.
It's a reasonable inference, Your Honor. Well, a lot of people have long commutes, Your Honor, and I think legally speaking, without more, beyond this complaint, without more, this simply does not reach that level of legally real harm.
It's wear and tear on the human being, drive this extra drive, or stay in the barracks with the person that you've made an accusation against, even if the accusation was properly dismissed, and I'm not saying it is, but you've now made an accusation. There's allegations of behavior that, whether they rise to a legal consequence or not, are inexcusable. So stay and be harassed or drive 4 more hours a day. Why doesn't that get you over the rail?
Well, Your Honor, it's common working environment that people drive to work. I would suggest under these circumstances, a longer commute simply does not get to the level of real harm.
But it's not just a longer commute. It's a longer commute or stay in that barracks with that set of circumstances.
Well, in that instance, Your Honor, he was given that option. He was given,
Right,
I understand what you're
that's
saying.
what the problem is.
Well, that's the problem, but I would suggest to the court that simply taking those at their face value, they simply do not amount to any adverse employment action. There's no material harm.
Do you have a case that's similar to this in terms of the option was to have a longer commute and that was deemed not to be an adverse employment consequence? Is there a reported case that says that?
Well, in my brief, I do cite a series of cases, Your Honor, where a longer commute simply, without more, was not considered a material adverse employment action. There's a long list of cases, Your Honor, in my brief indicating that.
The basis for the judge's dismissal of the retaliation claim was there was no adverse employment action, right?
Correct.
But she didn't, I think her general point was, well, Lieutenant Baker is just being told he can stay on in his current position. That's no change in the status quo. But I think if you look at the constructive discharge allegations and combine, the constructive discharge can be the basis for an adverse employment action and a retaliation claim, correct?
Correct.
So if we think there's enough stated there, and it seems to be, at least at the 12B6, of very adverse, intolerable working conditions, and you combine that with the retaliation claim, isn't there enough to get over the 12B6 threshold?
Well, in this particular case, Your Honor, that was, according to the complaint, Lieutenant Baker had filed a complaint of harassment around January 22nd of 2019.
Yeah.
At that point, the department began its investigation. There's no indication in the complaint, and absent from the complaint, is any type of harassment or retaliation in that time period. At the end of the investigation, the state police presented Lieutenant Baker with an option. They offered, we understand that you don't get along with Major Majensky. We are willing to transfer you to neighboring Troop H, South Boston, or Troop C.
With a 3-hour commute, right?
Correct.
And you look at the SJC's decision in Yee and say, when you consider, that was a little bit different. That was where Lieutenant Yee was trying to get the transfer and wouldn't. But sort of, that's an intensely kind of fact-based issue, right? And sort of, I think the Chief Justice's point is, at least on these allegations, where the option is either stay under these really objectively intolerable conditions, and they weren't intolerable only because Major Majensky wasn't there during the pendency of the internal affairs complaint. If you have that, and the other option is this kind of really transfer to two places with a faraway commute, it does seem to be at least something that should be developed factually, and maybe you have a good case at summary judgment that this wasn't in fact an adverse employment action, but I'm not sure how we can uphold that decision at this stage.
No, I understand it's a low threshold, Your Honor, but I just want to reiterate that under this particular complaint as worded, and as I do not have to remind this court that it is confined to the four corners of the complaint, based upon the wording of the complaint, even assuming everything in the complaint to be true, simply he complains of a longer commute. Attached to that is a time from his family, that it's dangerous driving conditions. Under those circumstances, I suggest as a matter of law, this court can look at that, even assuming, again, under the standard, that simply that does not amount to a adverse employment action. In working with Major Majensky, I would argue, does not amount to intolerable and unbearable working conditions.
Why doesn't it? I mean, there's a lot of evidence about, a lot of allegations, I'm sorry, not evidence, about Majensky sort of treating him very rudely, kind of dressing him down in front of inferior officers, making comments about his religion. I realize the religious claim is not before us now, but a lot of kind of unacceptable conduct is alleged. And isn't that enough to sort of establish objectively intolerable conditions for?
Well, now you fall into the realm of personal conflicts within the workplace, and I don't know if the courts want to get involved in that. In this particular case, we're in the context of retaliation claim, which I would suggest is a little higher level than having, let's say, a discrimination claim. I think a higher level of scrutiny applies in that it has to be intolerable, unbearable, and certainly aggregating circumstances. Under these particular facts as outlined in the complaint, that does not amount to intolerable, unbearable working conditions. It appears, and I think we can assume, that Lieutenant Baker simply didn't get along with Major Majensky.
Well, that's for sure. I just don't know if we can make an assessment. I mean, the judge sort of said, well, not every workplace's change is intolerable. And that may be true, and maybe ultimately what is decided on summary judgment or decided before a jury. I'm just not sure on this record we can sort of make that judgment because we're supposed to interpret the complaint and the allegations in the light most favorable to the pleader.
I'm also troubled by Warmington saying, essentially, I'm going to recuse, and then he doesn't. What do you say about that?
Well, from my understanding, Your Honor, and again, this is outside the record, Lieutenant Colonel Warmington, I believe at that time, was the Deputy Superintendent of the State Police. I know Lieutenant Baker had concerns about the investigating being transferred to the harassment unit, but that's what the harassment unit does. They investigate harassment cases. That's why it was transferred. As to why Colonel Warmington recused himself from that, I don't know.
Purported to, right? Because then he still signs the letter.
Well, I believe he signs a letter as the deputy superintendent of the state police. I don't know what the particular circumstances, whether there was a conflict he had in this case. But again, Your Honor, I don't believe any of that is really relevant to the issue before this court.
You know, I have a number of problems with this, and none of my comments are directed at you, Attorney Farrell. I know you can't defend the actions of all 2,000 troopers and officers in the department, but one thing that bothers me is this is not a regular workplace. You know, we call it the rough and tumble of the workplace. This is state police, and we expect a lot from them, as we see in court every day. When they deal with the public, that they have to deal with the public fairly. It's a dangerous job. We ask a lot of them. So I think it becomes even more difficult if we have troopers or an officer in this, a lieutenant in this particular case, who's being treated very unfairly in his own barracks. And then we're asking him to go out and treat the public, you know, fairly and impartially and so forth. So it's not just a regular workplace. I think there is something else at work here. And the other thing is that puzzles me, maybe you can answer it for me. Why would the state police offer to transfer the lieutenant out of Troop D? In other words, how does that serve the interests of the state police? Because you're taking someone who has all the experience in that area. He has relationships with the local police. He has relationships with the local prosecutors, knows the community. Don't you want to keep, doesn't the state police, not you, doesn't the state police want to keep someone like that, of that caliber, in that area instead of uprooting him after 26 years and putting him somewhere else? In other words, that, to me, that kind of bespeaks a retaliatory intent, because it's inconsistent with the interests of the state police to do that. What do you say to that?
Well, Your Honor, it's not unique to the state police that there are interpersonal conflicts amongst employees and employers, subordinates, and supervisors. This is just a typical workplace situation that exists in a lot of workplaces, not just the state police.
I mean, this was pretty bad. I mean, you had the incident with the classmate, which was just seemed petty. You know, he couldn't attend the ceremony or the send-off for his classmate. Passed over for promotions by people of inferior rank and quality. Sure, that does happen in the workplace generally, but it's troubling nonetheless. But then this really troubled me, the condemnation for his investigation of a fellow trooper, which must have been a very difficult position to be in, but he's condemned for that by his superior. That's very troubling. And then all the mocking and kind of the juvenile behavior that followed, which remarkably turned out to not be unbecoming conduct of a trooper for some reason. But that's not the end of the story, because then everything shifts after that, and that's where we have the case being steered from IAD to the lieutenant colonel, who said he was going to recuse himself and then didn't, and then the ultimatum basically at the end. So it shifted from all this bad behavior to what seems to be retaliation. And at this level, a plaintiff really doesn't have to demonstrate that much. So why isn't that enough for it to go forward?
Well, first of all, Your Honor, I'd submit that the circumstances you just described are not in this record. I understand that. This case was investigated. It was investigated by the state police. It was determined to be unfounded. There was an MCAD investigation. They dismissed that case for lack of probable cause. And I think what you're saying is this is not unique to the state police. Again, do the courts want to get involved in being a super personnel department in regulating employer behavior? In this particular case, I submit that this is simply that. There was a personality conflict that simply, legally speaking, does not meet the threshold requirements and elements of a retaliation claim or a constructive discharge claim, in that these behaviors were not so intolerable and unbearable that there was no other option. Lieutenant Baker chose to resign and to retire, which he did. And in closing, I just want to add that there was no adverse employment action. It was simply an offer for these options. He rejected that, found them unacceptable, and he retired.
We will have to leave it there.
All right,
Thank you
Your Honor.
both. The case is under advisement.
Thank you.
This concludes this morning's or today's session of the Appeals Court. I'd like to thank our court staff, in particular our court officers, our law clerks, and our wonderful timekeeper. We are in recess.